because in Europe, which is proud of being the root of civilization, here started the two worst wars of the history. Now we can put the question, is it still the same union? I am very glad that the 10th anniversary of Bratislava Legal Days, that is this conference which is dealing with the influence of the European law on the national law, has a chance to answer many questions. As the rector said, a good question is better than the answer, because it makes us to think about it. If we are not decided and we are not interested in the other part, but we are interested, is it correct that we prefer the European law at the cost of the national law? We joined the EU as a sovereign national states. And this is the basis of our sovereignty, and our law has to have clear rules, and the European law as well. I believe that here is a big potential to discuss it and tackle many problems, even resolutions we will need for the next period. Today we witness the European Union through the European Commission. This is what we have to divide very clearly. The European Union is a wonderful project, excellent. As I said, it is the project which was even awarded a Nobel Prize in 2012 for the peace, but the European Commission is its top representative. Many times we see efforts to interfere with the sovereign rights of the national member states in a political way. And this is what we didn't want. I don't want to make a big comment to current topics. I'm sure that the Minister of Justice will speak about it sufficiently, but we have to ask whether we want it. I'm convinced that we do not want it, because otherwise we would go to the crossroad which could result in Brexit or similar activity like Brexit was. But let me speak about V4. V4 experiences its historical period, but I'm convinced that it has its irreplaceable place in the Eastern Europe. I can give you a good example. It is based on the experience we didn't experience as Middle European countries. It is migration experienced by the Western countries, because they experienced in the past the colonization and so on. But we didn't have these experiences, and therefore we naturally joined in the subject of the illegal migration, because we are open to the migration which has clear rules and limits, but we are not open to the illegal migration. We established the Schengen in order to enable us to freely move, and the joint cooperation of the V4 hopefully will be a good example of cooperation also in the future, like, for example, the big challenge by the European Commission, and it is abolishment of the veto right. But it is necessary to join each other there when we have common interest. Sometimes it can happen we do not share the common interest or opinion, but it is quite natural. It is also in the private life. But I'm convinced that we are responsible for the future of our state. We have to leave our countries prosperous and peaceful to next generations. And this is where we need your support. not only the professional point of view, but also non-professional point of view. And I wish you, let me wish you a lot of excellent discussions during these 3 days. And let me tell you that the conference like this also in the future will be Europe-wide prestigious, and I hope that these European Legal Days will become European legal days. Thank you very much for your attention. Thank you very much, Minister. The plenary session is divided into 3 panels. Now I wish to ask the first panelists to take their seats. And let me ask the Dean Professor Eduard Burda, who will moderate this panel discussion.
Dear Mr. Minister of Foreign Affairs, dear Mr. Rector, dear Mr. Ministers, dear State Secretary or State Secretaries, dear Chairman of the Supreme Courts, dear Law Chambers Chairman, I am welcoming you at the 10th anniversary of our regular conference of Law Forum, and we dedicate it to the impact of the European law on the national laws. As it oftentimes is, this is the 10th anniversary, and this conference had a predecessor who forced us to think that such a forum will be regular. The predecessor was a big conference in 2010, and its title was not Bratislava Law Forum, but Law as a Unifier of Europe. Law as a Unifier of Europe. What we meant by that? In 2010, of course, there was a different situation than today, and the current situation is, let's say, more skeptical. In 2010, the situation was more optimistic. After entering the EU, we, as the lawyers, were thinking about ways how to ease the life of people, how the law to be harmonized and get it to a practical level. Within such discussions, besides the word harmonization of the law, there was also mentioned the word unification of the law, that the law should be in a way unified in a certain level. The overwhelming ideas in 2010 were such that unification of the law within the EU cannot be performed. Let's look at the United States, which sometimes they are put as an example. The United States do not have unified law. They have unified some areas of the federal law, but despite of the fact that they are culturally more homogeneous than Europe from the point of view of some territories, but they kept their identity of their states. Today, in 2024, the situation is a different one. Today, we have more laws of the EU more acts, and the discussion about their bindingness starts to be put at a level that something like we would not have any recommendations that everything needs to be exactly transposed. There are discussions that some directives need to be transposed at the level of their exact wording, which was not the purpose of the directives. And here we need to say that each activity has a reaction. Therefore, each action has a reaction. And we have, on one hand, more closeness, even up to a unification of the law, but there are, on the other hand, there are other tendencies. I am glad that in 2004 we entered the EU, that we had the referendum about it. I participated and voted for entry of Slovakia into the EU. But on the other hand, I have to say that I am not comfortable with that, how in some moments the EU is profiling itself. I believe that there are some cultural differences which impact the shape of the law in individual countries, and I'm afraid that if we want to delete them in a uniform way, then we will lose the roots and also sufficient base of the law, and subsequently it can lead to a splitting of the EU. Several years I heard some tendencies, even some weakly formulated, that stated that there is also another way than the European way, and that there is a need to be prepared for some splitting. Today we hear such a debate more often, and let's speak frankly, when the debate finishes in that way that the Union is going to be kept together, and in 1 or 2 years the debate can be evoked again, like in the case of Brexit, that let's split, and then when such a tendency is there, then there will be a difficulty to be unified again. So therefore I'm convinced that we have to speak on the scientific level, on society level, and also political level about that, where the Europe is going, and we need to formulate our opinions and not to be afraid of pointing out at deficiencies. Nevertheless, each society where there was stopped to be pointed out at deficiencies, or people were afraid to do so, they finished in decline, and we do not want that. So therefore, I hope very much that this conference, especially from the point of view of legislation and from the point of view of the EU, is impacting the life of the people within the EU, and this discussion can contribute, and the scientific outputs from this conference can be such that we can be proud of and praise what is good in the EU, and that we also put a mirror to the EU and to some efforts, and to point at that not everything that is stated on the central level has to be automatically adopted, and that it is useful also gradually to reform some things or adjust. If we have some efforts of unification of the law, they evoke the right opposite and reaction. Therefore, this should be about our conference, and where the limits are of the list, that within this panel we created together with the Ministry of Justice and with the Ministry of Justice of other V4 countries, a panel dedicated to the impacts and limits of the EU law on the national systems. And allow me now that I gradually ask to come to this panel our persons, Dr. Boris Susko, a PhD, the Minister of Justice of the Slovak Republic, Dr. Bence Tussan from the Ministry of Justice of Hungary, Zuzana Rudzinska-Bluszcz, the State Secretary of the Ministry of Justice of the Polish Republic, and Dr. Willem Anzenbacher, the PhD, the Deputy Minister of the Ministry of Justice of the Czech Republic. I would like to note that sorry, we cannot hear the Slovak language. There is
a následne to bude prebiehať formou moderovanej diskusie. Takže pán minister Susko, nech sa páči, máte slovo.
Minister Susko, it's your floor. Thank you for your word. Dear Mr. Dean, honorable guests, spectabilities, honorabilities, dear Mr. Ministers, State Secretaries, allow me that in the beginning I react to the questions posed at the beginning, and in this introductory part we should look at what I perceive the benefit of the EU membership for the jurisprudence, what is the negatives or what are the biggest challenges for the future within the EU law with respect to legislation. I am glad that the colleagues from the B4 countries, that the ministers and state secretaries from the Czech, Hungary, and the Polish Republic accepted the invitation to meet here in Bratislava, so that we can evaluate 20 years of union within the legislation. Since our entry to the EU, there was changed a lot, not only with us, but also within the EU. As our predecessors stated, it is not as it used to be 20 years ago when we entered the EU. And therefore, I am convinced that today there will be a lot to discuss. However, adjustment of our legislation to EU standards was not always comfortable for us, but we cannot forget to underline the benefits of being a part of the EU. The biggest benefit is the effectiveness of the cross-border cooperation. When we talk about cooperation, without which the citizens would not be able to use the freedom of movement. In the business law, there was a delivery of and which allowed us communication within the EU and also with the treaties. In the criminal law, there was improved the preparation, where we talked about the European warrant and other things. Within there are many harmonizations. We cannot forget about some standards in the process laws or standards in the protection of consumers, or also involvement of the justice with the standard. This cooperation is improved with consultations through the European Justice Network, and also with coordination at the Eurojustice. Another positive is the active possibility to participate in preparation of the EU legislation, which can be appreciated a lot. And many times the discussions in Brussels showed that also some smaller countries, they can join their requests, they can implement their interests, and therefore I am welcoming that in this conference we managed to be in this setup as before, that within the EU and Brussels we have many common interests, and if we join, then we can also enforce them through against some big states. And the last but the consultation with experts with other member countries, it is beneficial also for our internal initiatives, whether through non-formal contacts or through Brussels discussions or through legislation networks of the ministries of justice. And last but not least, we should not forget about the financing of the EU, through which we can use the improvement services for justice for prisons and parts of the sectors of the justice. If I should also express some negatives in the process of development of the EU, we will talk about them also further on, but in a framework I would like to draft some of them. It is to the decision of the Supreme Court of the EU, which is not always bringing benefits, but there are also some problems where there are some problems for in the last period there is in conflict. The jurisdiction of the Supreme Court is in conflict with the Supreme Court of the respective. We can perceive also some decisions for the private protection, for other laws, some protection of life or property, which can protect the law enforcement bodies. The jurisdiction contributed to laws of the EU, where there are complexities in discussion about the international laws, while the powers of the member countries are more and more restricted, and in some cases they bring external competencies of the EU and complication in international discussions and concluding contracts. The decision making by the qualified majority fastened to implement some regulations, but it has some negative impacts that not everybody is 100% satisfied. Moreover, more and more there is a risk of overcoming the legal base from the point of view of the EU by the majority decision making of individual states. On the other hand, even in unanimous, there was not more satisfaction, and the tools were not due to compromises used. Such negative examples are the European arrest warrant, which thanks to qualified majority became the most used tool in the justice cooperation. Negatively, I perceive the relations or efforts to expand the qualified majority in the area of the family law. There were the value issues. We as the member countries should protect our sovereignty and to be against such impact to sovereignty issues where we have also this case directly implemented in the constitution. These are such frameworks of positive and negatives. There are many more positives. Of course, we can talk also about more negatives that will be part of our further discussion. As for the challenges in front of the EU in the area of justice, there is the issue of digitization, the issue of the legal regulation online area from the point of view of criminality, computer crime, or some illegal activities in the online area. So here we are somehow lagging, and in the area of our discussion and European regulation we will tackle on that. Thank you very much.
Thank you very much, Minister. Now I would like to ask Minister Tuson, the Hungarian Justice Minister, to present his speech, please, Your Excellency.
Rektor úr, dékán úr, tisztelt miniszter urak, államtitkár, hölgyek és urak, tisztelt hölgyeim és uraim, nagy-nagy szeretettel és tisztelettel köszöntöm én is Önöket, és először is hadd mondjam el, hogy a mai reggelemet úgy kezdtem, hogy kimentem a Dunához megnézni a Dunának a vízállását, és érdeklődtem a szlovákiai árvízi védekezéssel kapcsolatban, és szeretnék gratulálni a szlovák vízügyi szakembereknek, hogy ilyen szépen sikerült rendben tartani az országot, megvédeni az embereket az árvízzel kapcsolatban. Vannak, akinek személyes tapasztalatai is voltak most az árvízi védekezésben. Mi most várjuk az árvíznek a nagy részét, a jó példát. Mi is igyekszünk ennek megfelelni és megvédeni az embereket, és ugyanakkor hát aggodalmunkat fejezzük ki mindenkivel.
We express our concerns with regard to all persons which have become the victims of the floods in the neighboring countries, and I wish them a lot of good luck and a good defense. When speaking about this current topic, the person should look at it with the reservation and to look at the European Union as a construction targeting at the success. We want to evaluate this issue. Therefore, we should look back in the history, because the world has not been changed, and the history has been working with small nations and big nations, and the states which have a strong economic military power, they have reduced always in the history the movement of smaller states, and they determined what the minor countries can do and what they cannot do. The European Union is a positive example because here are positions to protect the minor states. We have to compromise on the fact that there is an institution blocking minor institutions, institutions serving to to protect the sovereignty of minor states. We don't want to think about the European Union as an empire determined by big powers, but we should consider it as a commonwealth of nations, and the word is not changed. Speaking about the traditional efforts, they are permanently present, so there always will be powers striving to disturb, to break this balance, to break the measures protecting minor nations, minor states. And we witness these efforts when this system wants to liquidate the means protecting minor states. Here I have to state that it is important the functionality of the legal system, and which means are applied, if they are applied effectively, and whether they means exact requirements. We know it from the past. In the Soviet times, when these expectations were not exact, I mean expectations from other countries, and that non-exact expectations became insecure fluids. How we could comply with the socialist legal system when we have a legal system which is being dissolved, and there are elements which do not mean the exact expectations from individual states, it can cause a negative situation. And within the European Union, we can see the process like this, speaking about the law, individual member states shouldn't be examined with regard to the legal system. And the individual member states were afraid of that the European institutions being not controlled wouldn't be enough democratic. So these expectations were made, and this has been changed in the last time. And within the European Union, there is a system of inexact expectations. When we have such inexact expectations, this can be then changed to place of power, and even it can become a disciplinary action or means against some country. If some country doesn't agree to other countries, then we can take out from the drawer a yellow or red card for these inexact expectations, and the judicial system is good, or government of courts of justice. When the system of the courts of justice are governed by the justice minister. For example, in France, it is made by the executive power. In other countries, it is not like that. And somewhere, the courts of justice are independent. Each system can be good. Each system can comply with that, what we consider that it is the basic of the rule of law. If there are inexact expectations and the rulings are based on such expectations, then it leads to the fact that the rulings of some countries will be that some countries will not respect this ruling. And if some countries ignore the decisions made by the EU, this will lead to the disintegration of the European Union. For me, it is important that this system of the European Union is sour, that the decisions are based on exact basis, that we omit decisions against the individual countries, because this will break the system of the European Union. Currently, it seems that the European Union should be unanimous, but it will lead to the disintegration of the European Union, and this is also with our legal system, that that now they are multiplied, that this legal order of the European Union is becoming more and more complicated. The system of procedure has become more complicated. It is a big bureaucracy with lobbyists who invent new rules, and the legislation has become broader, which is then being reflected on the national system. Then it is chaotic and not transparent, and this is what evokes situations which are out of law, and the lawyer must be really a good specialist who can apply which law to which case. The artificial intelligence can help us a lot so far. We will discuss it, but I want to draw attention to the fact that each code of justice has a serious influence on the single legal system for the courts of justice. But we cannot forget that all the legal powers within the EU come from the national constitutions, and also the Hungarian constitution lays down that there are some legal powers which in Hungary, within its sovereignty, co-applies together with the European Union. And then we can see that it is such a mantinellism of the European Union, because there are national constitutions and we have not give up our powers, our competencies completely. The European Union has no competencies, no powers. So that what we didn't refer on to, that must remain sovereign. We cannot apply there the European law. When I rent my flat and this person sells my flat, it is against the law. So the legal competencies which we didn't refer to the European Union, these cannot be applied by the European Union, and we have to set some limits for frontiers, because when the EU disintegrates for the future, what will be the future of the EU? And what we consider to be the target sphere of the future of the EU. We are now chairing the European Union, and we see that the competitiveness of the European Union also in the legislation should focus on competitiveness. So far, we brought some topics. When we look at the EU from this aspect, we can state that this is how the EU can be preserved as a unified Commonwealth, able to compete with the US or with China. Thank you very much that you were listening to me. Thank you very much. Now I would like to ask the State Secretary, Ms. Rudzinska, ladies and gentlemen, dear ministers, esteemed public, thank you very much for this invitation. I'm very glad that I can represent here Poland, here in Bratislava at this conference. In the group of friends, we joined together the EU 20 years ago. So, as my predecessor said, my heart belongs to all victims of this flood the solidarity was born also in Poland. It is also very important for our region. Therefore, I want to express our support and solidarity to everybody who is taking care of victims of floods. The European Union is not the same union as it was 20 years ago. It's enough to say that it is many years. 20 years ago, I attended Erasmus in the UK, which was at the time a member state of the EU. Now I am here like a state secretary, so 20 years are many years. Speaking about the fields which I perceive to be the best successes of the EU. It is especially in strengthening of cooperation. We citizens of the EU are protected, and in all states and offenders, criminal offenders, can be prosecuted also out of our territory on the basis of the European arrest warrant, and our organs, justice organs, work within the Euro Justice and others, and we have also a cross-border cooperation, mutual cooperation in judicial issues, European cooperation. The European payment order, this is one kind of cooperation. The second value is an access to the European funds, enabling us to teach the lawyers. We have got the infrastructure we can build up with regard to the cooperation. And the third area, and I think that after the Polish experience, I think it is the most important area. It is a certain harmonization, not only the unification, but also harmonization of standards in affecting the improvement of information in the individual member states. The harmonization is based on the European values. We should ask what is important from the part of the European Union. After the last 80 years in Poland, the EU gave us the European values which are protected by the European Union. These values are not just on the paper, but they are our common basis. It is the second article of the EU treaty. I would like to quote it because I think that it is good to quote these basic things. The European Union is based on equality, rule of law, human rights protection, and minority values. This is our common basis laid down by the European Union. Which showed us in 2004 that we have to become members and to be there, and the main protector of our rights is the European Court of Justice, rule of law. For us in Poland, it is very important to have it. The rule of law, which has to be protected, is necessary also for the internal market, and it is also important for the mutual cooperation in the area of justice. It is also necessary to ensure that the justice in member states, which are also European judges, fulfill their tasks in an independent manner. To summarize, the EU has developed the Court of Justice. We will speak about it today. When we take the case of Portuguese judges, when the Court of Justice determined that it has the right to assess the rulings with regard to the justice in the European Union, has issued several judgments important for the Constitutional Court in Poland. The EU has introduced the conditionality or regular annual report on the status of justice, preservance of justice, and I think that this union is prepared to face these challenges more than it was 20 years ago. Thank you for your attention.
Teraz na mne
Thank you very much. Now I wish to ask the Czech Deputy Justice Minister, Mr. Hanselmacher.
Dobrý den, vážení páni ministři.
Good morning, dear ministers, ladies and gentlemen.
Zde projevujete se zeměmi zatopenými povodněmi. Je to věc, která je v České republice mimořádná, ale naštěstí
There is an extraordinary situation in the Czech Republic, and we are trying to manage it as good as possible. We are trying to minimize the damages at property and lives. It is an honor for me to meet you and to reflect on the changes that our countries went through in the justice area in the 20 years since our accession to the EU. Today, when we look backwards, it is obvious that our membership in the EU and of the EU laws was essential and beneficial. Allow me now to think of some aspects that are key for the Czech justice and all the legal system in the Czech Republic. As the benefit for the justice was the harmonization of the EU legislation with the EU laws, and with the enforcement of the law and the enforcement and with the laws of the EU. To improve the legislation of the legal system, whether it is civic or business legislation, the harmonization contributed to the legal regulations of the European Union, and it simplified the cooperation in the legislation, criminal law, and also cooperation in commercial law, and also the relationships in the whole area. In the criminal law, with our entry to the EU, we were involved in initiatives that were actually directed at our cooperation. We actually had the European Arrest and Eurojust and the European Justice Network, which help in a very fundamental way to bring together criminals to justice in the area without internal borders. This is not only leading to a better fight against cross-border crime, but also it contributes to ensuring that criminals cannot hide from justice in other EU countries. The structures of Eurojust, we just today play a key role in the fight against organized crime, terrorism, human trafficking. There was adopted a lot of rules that protect that is the right for the translation and legal representative, and also the evidence. And we have the impact very positive in the cooperation in the civil issues. We can say that I have to underline the establishment of the European Public Prosecutor's Office, which essentially took over the powers of the National Public Prosecutor's Office when it comes to crimes related to violations and threats to the EU financial interests. The office, which has been operating since June 21, increases every year the number of investigations it initiates, as well as the value of the property that is secured as part of its activities. Currently, 24 member states are participating in the enhanced cooperation on the establishment of the office. Even from this, it can be concluded that such an institution at the EU-wide level can function and have its place in criminal proceedings, although of course it cannot be claimed that its functioning is completely flawless. Thanks to accession to the EU, great emphasis is now also placed in our countries on ensuring the rights of accused persons and victims of crimes. A number of directives have been adopted to protect the rights of the accused in criminal proceedings. For example, the right of an interpreter and translation, the right to legal representative, access to evidence. At the same time, the protection of the rights of victims of crimes has been improved through directives that ensure better support and compensation for victims. As a specific area where the Union's influence has manifested its main positively, we can highlight judicial cooperation in civil matters, in other words, Union's activities in the field of international private and procedural law. The regulations adopted here address the main issues related to legal relations and proceedings with an international element. They do not intensively enter into national legal systems as they focus on those aspects of private law that relate to cross-border situations. In principle, it is a matter of cooperation, not harmonization of national legislation. Thus, on the one hand, the functionality of the European judicial area is ensured, and on the other hand, its internal diversity is respected. A fundamental benefit of judicial cooperation in civil matters is the simplified recognition and enforcement of court decisions between the member states. This is extremely important for both citizens and businesses who can rely on their rights being protected abroad with having to go through long and complicated procedures. This principle strengthens trust in the legal system among both individuals and businesses and also supports the free movement of people, services, and capital within the single market. The benefits in the field of family law cannot be neglected, for example, in cases of divorce, child custody, or alimony determination. The Union has made it possible to create rules that protect the interests of children and families, ensuring that these often sensitive matters are dealt with fairly and effectively, regardless of the member state in which the parties are located. The implementation of insolvency legislation was also a challenge. For a relatively long time, the Czech Republic has been dealing with the transposition of Directive 2019-1023 of the European Parliament. I am very much looking forward for the discussion in this area. Thanks to all the speakers. The following questions will be dedicated to all speakers, and therefore I would like to ask you that you answer one by one. The order would be up to you. When there will be some specifics, I will ask the specific speaker. The developed countries, which are considered also the EU countries, from my point of view, have problems that they want to set up rules for everything. That means that oftentimes we can see that many areas have a lot of regulation, that over-regulation exists, and in this process it is making more complex the simple life to people, that there is a lot of permits necessary which are there. The EU is also bringing a lot of regulation and in some areas over-regulation. In your opinion, where can you see the areas of law where the Union already goes too far within regulation or over-regulation, where it should stop or minimize, even go backwards, make a reverse step to simplify it, and where you can see the areas that require further level of regulation in order that the processes within the EU and relations operate well. In my opinion, it is better to think of a situation to go a step back, not to select one specific area, but to think of general issues, whether there is a need for such a level of regulations and legal standards. The best way in my opinion, in creation the regulation is to think whether such a regulation is really necessary, whether it is inevitable that it is created, because there is a lot of casuistic regulations which are then complemented and amended. One casuistic norm, legal norm, creates a spiral where you need to constantly amend. Therefore, I would like to mention one of my loved essays, 8 ways how not to be successful in creating law. Everybody, probably officer in the EU and politician in the EU, they should think of it, because not always a good intention in relation to regulation can be successful in the context of the law. Thank you for your question. We need to say that in the recent period we are witnesses of regulation in the justice, in the criminal law, where it would make a sense to go from unanimity to majority decision, but enhancing in other activities would rather mean that be better in the consolidation of the existing regulation than adopting some new ones. There are areas like we can expect regulation that can be beneficial, like contractual relations, concluding online contracts, especially in the online area where the national legislation is not sufficient, because in online services we are overstepping the borders of the country. So in such cases I can imagine the regulation, but the internal things like family law or cultural ethical issues, there I can see the space to be less, smaller. The regulation is one thing, but what is more important is the interpretation of such a regulation. And I need to say that in the recent period, oftentimes I am not pleasantly surprised that with the discussions at the level of the EU administration, EU Commission, and some directorates, which have a tendency to interpret the regulation and directives more broader than the directives impose the obligations on member states by supporting the treaty, the treaty and European principles. There, where the administrative officers of the EU, by their subjective opinion, consider insufficient the regulations, by their subjective opinion they want to force individual countries or Slovak Republic to application of general principles of functioning the European Union over the framework of functioning of the EU. And here we need to somehow create our own opinion. Mr. Minister. Thank you. Absolutely, I agree with your minister. I would like to say in this respect and underline that behind European Union there is a machinery of bureaucracy, and each bureaucracy wants to prove its meaning, and it started to generate a lot of adjustments, amendments. Therefore, we have a lot of amendments to the regulation, and not only the spiral. I agree fully that this spiral, they will start not only at the level of the EU, but also at the national levels. There will be produced different laws and regulations, and as I mentioned, there is created an chaotic network of legal system. And so if you look at it compared to the law systems, 20 years ago. Today we have a very complex system. At that time I worked as the plenipotentiary of the government, and simply we have excluded a lot of legal regulations, and they do not, we are not missing them. So we learned that simplification of the legal system is not an illusion, but it's a reality. We really need to convince the bureaucracy about that they should create less legislation, not to be involved in certain things, because for me it is probable that the sense of bureaucracy is probably will not be able to hinder, but if we do not start also changing the decision-making process in the EU, it will be not managed. We will need to be it will be not sufficient to concentrate on the legal systems and that support the competitiveness of the EU. Let's take, for example, the law on personal data protection, whether it is really protecting the personal data, whether it's helping the competitiveness of the European companies against the American or Chinese companies. We should think also of how operate big technical companies in the US or China. We would not manage to force them that they implement the European data protection laws. If we cannot manage that, and if we were not able in the forthcoming people to simplify our legislation system, I'm thinking of the EU and national legislation. The EU is growing and more and expanding. Then we need to increase the transparency of the system. We in Hungary, in this connection, have started a very serious project. I would like to turn your attention. We would like to transform our set of laws, the register of laws, by which we would like to help the lawyers to get oriented in this complex system when dealing with a problem that they find such laws in the system and regulations that are related to the specific problem, and in the next route, so that they can extract some regulations from that and laws at the level of the EU, and at the same time already existing decisions of law of courts, plus related some articles, expert articles related to the issue. It is really a serious development. We involved the best IT experts so that they create a database, and in the end of the next year we are planning to start off the system so that it is more transparent. Our systems. This system is very important because, in my opinion, the transparency is a very important thing from 2 points. The first, that the countries are competitive if somebody comes to Slovakia, for example, and wants to invest, or in Poland or Czech Republic, so that he knows what kind of laws there are and he needs to operate with. Today, for a big company, it is impossible that when it enters to Hungary, and I need to take this company with hand through the whole system if they want to build a company. But it is also important for the citizens, so they are not taken out, they are outsiders in the system. And here the minister stated a very important issue. There are areas where, on the other hand, were not included into the EU laws, however they would be necessary. Yes, we have the online contracts when people want to conclude contracts through online platforms, because this is a relatively new phenomenon which was evoked in the last 2 years. In online platforms, they sell not only products but also the product of third parties, and within one purchase we note that we are in the legal relationship with 3, 4, 5 entities, and we should implement our consumer rights with 4 countries. Maybe in the future we will be buying more products in this way, but online purchases became such in this way outside of the legal system, because nobody will be able to enforce his own rights or to go to the court against somebody. And we can see that these laws are implemented more and more on these platforms, and we can see that the European Union has something to do so that it unifies these online transactions so that they are unified rules, that people are not out of the law area, and they have the right to apply their rights through the EU laws. I believe that I would add 4 points when talking about the EU legislation. First, I agree with the speakers that the EU should not speak about quantity but quality of legislation and dedicate more attention to the impacts of the regulation. The second, in the Union legislation, we should be more focusing on leveling the unification and harmonization on the other hand, and to keeping enough space for member countries so that they get adjusted. The third, the values that I spoke about and the base of the EU, each legislation should go back to them and to establish itself on themselves. As the speaker said, the Union, as we say, should be forward-looking, should not be obsolete, old, but should get adjusted to the 21st century, and also should look forward ahead and to adjust to the society cases. Thank you, the State Secretary. Allow me that in this contribution I see some things that we need to touch, like competitiveness of the state. And I would like to follow up on the Mr. Minister Susko's speech, because the interpretation of the law is more important than the regulation itself, because, as we say in a big old joke, when there are 2 lawyers, there are at least 3 legal opinions. And I believe that do not believe that it applies in most cases, but we can think about it. And when the law goes to politics, or when it serves to politics, the interpretation can be many more. I can see, and I want to ask, what can we do? Because in this interpretation we can see 2 problems within the EU. The one, the problem is rather a political one, that when you look at the discussion, the political discussion, not only in Slovakia, but in our countries, but also in V4 and abroad, like the US, 20 years ago, it was more kind. Yes, there were some quarrels, there were some affairs about a political competitor, but it was not common that people were blaming each other or that they are criminals. But today, it is a very common thing. Mr. Blanner, the minister, said that there is a double measure for metering. In the EU, we can speak about it, in the news about the rule of law. We have cancelled the office of the special prosecutors. There were some comments that were leading up to that, that we could be stopped the Eurofunds for that. We know that Bulgaria, in cancelling these specific bodies, went even further, but there might be a double measuring, because on one hand there is required a transparency of processes. The EU requires this from member countries, but when COVID vaccination and when communication of von der Leyen was there, that it is far away from transparency. So one thing is, should we be tacit because it's the European Commission's President, or we should speak about it. I'm of the other opinion, but at second line, as Mr. Minister Susko said, is the officers, and I'm asking, I know some of them, I know some of their opinions of how the administration should be done before they became officers, and when they became the officers, how changed it their view of dealing with things. There I have rather a bureaucratic approach. My question is, the EU wants to save in the EU countries. If there are many EU officers, they are looking for agendas. Is not there a way of streamlining the agenda, that we also streamline the number of officers within the European institutions? Is it a discussion that should be taken within the EU as a positive one? Mr. Minister, thanks for the word. You followed up on my words, so I would only repeat myself as I stated that my personal experience with the negotiations at the level of the EU Commission are such that such an administration sometimes is trying to overuse the regulations itself. And when we compare with other countries, it's not approaching it with one type of meter. I cannot evaluate whether streamlining or narrowing the quantity of officers in the European Commission or administration is the correct step. I don't have statistical data on that, but I think rather we should think of the approach to the individual member countries is equal in implementing the requirements when asking to fulfill the conditions of individual directives. But as far as directives are concerned, there are limitations set clearly. And there is another subjective question: when the administration subjectively considers whether somebody is complying with the general rules of complying with the European Treaty. Here, we probably need to point out that the fact that the administration is not approaching with equal meter to individual member countries. Thank you. And I would like this trying to conclude to some conclusions, if you agree, that probably simply the EU should try that for each member country there are used the same conditions and not double kind of meters, and that it should not overcome some or overstep some frameworks. Mr. Minister.
I fully agree with this opinion. What are the original conventions or treaties, the possibility to apply a double meter for the individual member states? Political powers of some member states make this mistake. They attract also institutions of the European Union for their internal matters. We cannot make internal political discussions leaning on the European Union, because the country will be too much dependent on the administration of the EU. The European Commission controls the member states and doesn't look at itself as a body which should enhance the rule of law, but the European Commission has changed to a disciplinary body. And the reports of individual countries are a good example for this, and these reports that don't only mean the statements of some opinion, but they also contain requirements to individual countries. When not fulfilled, then these countries will be reproached if not fulfilled. The European Commission is not a safeguard or protector or guard of the European Union, but it behaves like a political body. It behaves like a government. We cannot wonder. When we create a body which is similar to the government, then this body will behave like a government. And when we delegate various politicians, these politicians and their commission will behave like a political commission, and we have to go back to the original role of the commission. It won't be easy because the European bureaucracy supports the European Commission, and if you know the EU commissioners, then you know that the area of power is limited, and such a member of commission cannot select its own staff, but this staff is actually enforced to him. So also the members of the commission are limited in their activities. And it also applies to the European Commission, because the administration at the background takes decisions how the Commission should work and act, and it is a bad trend, because the European Commission is then limited or sets boundaries from people of the EU, from the states of EU, and we can see that this institution has divided itself and also separated itself from the nations. The Commission is in the hands of the administration, and very often the European Council doesn't perceive whether the decision is correct or not, because they don't feel the logistic power, that is the lobbying, which is at the background, and that doesn't know which influence these decisions have on individual member countries, because they don't have such a background like the European Commission. It is a dangerous process. We have to set boundaries and go back to the regional basis, and we will later also speak about the European Court of Justice, about its role, because with regard to the monopoly of interpretation of the law, when we don't have it in our hands, it will lead to the disintegration of the European Union. Please, Madam State Secretary. We will speak about the Court of Justice. I wanted to speak about it, of the European Court of Justice, because it's great of justice. It must be based on the mutual trust. It is the basis. We have to ensure the independence of our courts of justice. To make them independent, we have to recognize that the national courts of justice are still courts of justice of the European Union. And the European Union can, through its European Court of Justice, can use its competencies and examine whether the rules of national courts of justice ensure this independence. On the one hand, I understand the discussion running in our states. More or less it is a state within the state, and this discussion runs for a longer time, and it is a philosophical discussion. What I expect from the Union is to be effective, not to be just somehow directive. And in case of Poland, we saw that the Union can be effective and intervene in the issues which are the key issues. And this was also in the case of independence and protection of the Polish judicial system. I would like to speak about the role of the European Court of Justice, which plays a significant role when unifying interpretation of the European law and interpretation of the rights. On the other hand, it reflects the already issued rulings of the European Court of Justice. As it happens sometimes at the top bodies, sometimes they forget that during the whole existence they should aspire to improve itself and revise their effectivity, their activities, their outputs. In my opinion, it would be good if the ruling or judgments of the European Court of Justice would be better grounded, the reasonings should be more complex. I think it would very much enhance the transparency of the whole decision-making and would enable us to respect more these decisions. Yes, I would also like to put another question. For the European continental system, it is not typical to have its own because the judge has to interpret and he shouldn't look for precedences where there are no precedences, whereas in the US English legal system, the judges create this right. The European Union as a project participated in the past also by the United Kingdom. I think that the European legal system took over from the English legal system. The question is whether we have no tradition so far in this way, and maybe our judges, but it also refers to the European Court of Justice, that the judges maybe change their role and interpret the law in a broader spectrum than they should. The question is whether this is the correct way, whether we want to act like this also in the future, whether we strengthen this judicial, this creation of law by judges, or whether we will regulate it. I don't know what should prevail, but we should think about it. Please, Minister. Thank you. I need to tell that the European Court of Justice is irreplaceable when assessing the European law, which is necessary for functioning of the European judicial system. We have to state, and it should be also stated by the European Court of Justice, that the regulation within the EU should be based on the principles of subsidiarity and proportionality. And these are two principles which should be always existent when the European Court of Justice makes judgments, decisions. Sometimes we feel that this European Court of Justice seeks to strengthen the role of the European Union at costs of preservance of legal traditions of member states. In the last time, in spite of the fact that the Court of Justice speaks about the respecting the constitutional identity of member states, however, some decisions are contradictory to the judgments of individual countries, member countries. So this topic should be considered, whether the Court of Justice, the European Court of Justice, should enhance the European Union or should respect the constitutional traditions of member states and should also take into consideration the jurisdiction of member states. Mr. Minister, please. I wish to react on that what Dean said a couple of minutes ago. As a matter of fact, we are based on the Roman continental law and the principle which we acknowledge. It means that the judge has no power to create a law. But this is a different case in the overseas countries. The European Court of Justice, regarding the fact that the European law is based on the law of European Union, starts expanding its competencies and powers. This has a serious consequence. We should think about it. So, as our colleague from the Czech Republic said, that we should reassess the whole legislation practice of the European Court of Justice and proceedings which are applied there. It doesn't work that the judges are intransparently appointed. It is right that should be applicable at the European level. It means that the judges should be transparently appointed. I think this is a big problem. The decision who will judge some dispute, it is appointed out of us. We cannot imagine it at home. This should be changed. And then there was a question of reasoning, how deep, how detailedly should be reasoned the decisions, because this is also the principle of ethics. The last decision referred to Hungary, that border protection and the stopping of migration was, and how it was made in Hungary contradicts to the European Union. The European Union initiated a dispute with Hungary and calculated according to their rules, but these rules are at least transparent, that how much fines should Hungary get. And the European Court of Justice increased this fine by 20 times, so it is 20 million euro. The reason was that they didn't comply with their duties, so just they invented some sum without giving its reasons there too. It wasn't clarified at all, so they just determined some fine. And it is really contradictory to the principle of honor. They didn't tell us why this fine for Hungary is so high. So these procedures should be built up, because if not, then there will be created a kind of judicial aristocracy which would make damage to all countries, because the Court of Justice of the European Union is not a lonely island. Madam State Secretary, partially I can agree, but I would like to go back to two topics. First, there are two mechanisms which in Poland in this non-precedented situation which occurred in Poland with regard to the judicial independency. There were two tools which were very effective. First of all, the procedures from the Article 266, the functioning of the European Union, that is pre-judicial procedure, and the second procedure which was applied by the European Court of Justice, and it was Article 254, and it is a procedure initiated by the European Commission. But here the main role is played by the European Court of Justice. With regard to Poland, it turned out to be very effective. The third tool, which was applied not only to the rule of law and turned out to be very effective, was Article 279. That it is not only about the rule of law, but also about further procedures which were stopped thanks to the procedure of the Luxembourg Court of Justice. With regard to the negatives of working of the European Court of Justice, I can tell that their period of decision is a very long term, because they require a lot of time. Thank you very much, Deputy Prime Minister. From the point of view of the substance of the rule of law, I wish to enhance my Polish colleague, because the tempo of making decisions should be compliable, and we in the Czech Republic are able to make good periods. They are not long-lasting. Some decisions by the European Court of Justice very often arrive very late, and it affects the substance of the decision and its justification. Moreover, we also need or wish that the European Court of Justice that the Court of Justice should more consequently discuss its decisions with national courts of justice, because due to online communication or based on conferences, I feel that we in the Czech Republic would appreciate more communication and exchange of opinions between the European Court of Justice and the local Czech courts of justice.
There is such a provocative question: the relation of the constitutional laws of the national countries and the EU laws. I perceive it as a topic that is not clarified until there is a strong fight within the countries of the EU. So nobody is taking some position to that. So can we say whether the precedence is by the constitution of the member country or the EU law? I can give a different round. So the State Secretary now is the first one to speak. In this case, it is a very topical question. Each country should somehow adhere to the line of the constitutional court of its country, because the constitution of each country is the basic element of the identity of the country, and the constitutions differ. Like the cash law, it was also a part of our constitutional discussions, and in this case the Court of the European Union should respect the constitution. The State Secretary. Dear ladies and gentlemen, I think that we could sit here for hours and speak about examples from Poland, which took place in the beginning of our discussion. We stated that a well-posed question is better than several bad answers. But what can do the EU? What can do the citizens who believe in the second article? I quoted that if there is damage, the rule of law and the constitution in the given country, as I mentioned, which was already confirmed by the European Tribunal, by the European Human Rights Court and the Luxembourg Court, because if there is a decision, the second article is not in line with the Polish constitution. The situation actually is more complex than we could decide here in our discussion, and therefore I believe that it was interesting how the EU reacted to the situation in Poland. They were looking for new ways to ensure the minimal protection of the base that is connecting us in the EU, and these are mentioned in the second article. Therefore, on the other hand, I would like to mention that the constitutions are extraordinarily important. They are somehow like an indicator of abiding to our internal legislation, and here we are being the first line in the EU. If the internal law is not in line with the directives, then there is applied the EU law. But in further years, the Union will have to search within institutions the tools to ensure the compliance of the procedures of internal bodies with the European laws. Minister? Yeah. The well-posed question was that we compare our constitutions. What is the first thing, what is having the precedence, the national constitution? The question it posed in this way, the answer is the national laws have a clear priority against the EU. The EU doesn't have such rights that would result from constitution. Therefore, the EU should not have more rights than the laws to which they are eligible by the constitution. The European Court should not adopt such decisions that would be in contrary with the constitutions of the national countries. If it's not the case, then it creates legal uncertainty, because the European Court has already such decisions that ban to a concrete court to perform the decision of the constitutional court of that country. This is a nonsense. That European court takes away to a country the right to interpretation of the national legislation. That is a nonsense. This is the part that the European Court cannot go. What has the priority? Which law? No, the question of constitutional law is different, because here we in a certain way share our sovereignty. The institutional system has some competencies, and here the two systems are in a competitive relation. And there are some regulations of the EU that can be directly applied, but whether it complies with the national legislation, this is a question to decide by the Constitutional Court. It is a complex issue. Hungary simplifies its opinion, its position. I believe that the decisions of the European courts should be adopted only when considering the national courts' decisions, and not to adopt any decisions against the decisions of the national courts. That should be correct, in my opinion. Minister Susko, in this well-posed question, which is very complex, we should go back 20 years ago when we entered the EU and when we looked at what kind of sovereign rights we have got rid of. We said ourselves that we are not getting rid of our constitutional rights. The conflict between our constitution and guaranteed constitutional rights, even saying that our law is in conformity with the EU laws, but in the recent period it becomes also a part of the conflict decision making of the Slovak courts and the European Court. We could see it also in the last decision of the Constitutional Court in relation to the amendment of the criminal law when implementing the Lex Mizio articles, when the Constitutional Court said what should be the way it should be implemented, but we have the EU Constitutional Court's decision which decides about this rule differently. So here there are concrete things that result from the Constitution and basic principles which the European Court of Justice is interpreting recently differently than the constitutions of member countries, and also than common practice. Here I would like to follow up on the rule of law. 10-15 years ago I thought that I knew what was rule of law, but today I'm not so sure what it means and what it covers all. Therefore my question is that we can see in the report on rule of law that there are covered many areas, and sometimes these are areas that were not perceived as a typical part of the rule of law, like the media. It was directly in the classical word sense was not covered. The freedom of word or speech. How do you think we should treat this term? Whether there should not be some more clear interpretation what it is meant by it? Because the state is represented by its bodies, the relations between its institutions, bodies are quite clear. The question is in what depths the state can change some bodies once they are already established, and how much the European Union can influence that. What do you think, Mr. Minister? Believe that we are at the level of the EU and we convicted a lot of errors, because it is not indifferent who interprets the term of the rule of law. because it's our emotion. It's such a definition which creates whether it is a variable system of requirements and criteria, or it is a system of expecting criteria that can be clarified within a normal discussion. There would be a good thing to go to the original route. I consider a big error that there exists in the EU something like that the Commission formulates the content of the notion of rule of law. You can imagine there are some bureaucrats who have some idea of member countries, and these bureaucrats, on the basis of some impulse, they formulate their opinion or standpoint to a rule of law system, whether it's good or not. We Hungarians many times in the past lived it, and there are also countries such, I'm not going to mention these, who approached us because they were afraid that when already happened that some criteria were imposed on Hungary, they understood or they felt a threat that no member country is protected against such a thing. We should not expect from the European member countries that they are not the rule of law countries, because when creating institutional system and the creation of legislation, when we clearly did not say that all these questions will be controlled in the discussion, we admitted a big error because the whole sense of the European Union moved to a different aspect, because we got to a point that European Union wants to somehow punish some countries instead of that it supports that they are successful, and this is damaging the EU. Its importance is deteriorating, and some prognosis already support that the EU in the forthcoming period by 2030 from among member countries of the EU, probably we will be happy that one or two countries, member countries, will be the best, among the best in the global ranking. And when we look at the statistics of the economic growth of the EU, we can see that we as the EU, we will be lagging in compared to our competitors. We should focus on issues that are important, that we are not building up here sandcastles that we will use for political disciplining of individual member countries. I'm saying this because this is being handled in individual member countries as a problem, and this generates internal discussions because the institutional system of the EU is considered something like a punishment, a punishing institution for individual member countries. Minister, please, your word. I believe that in this auditorium we all know what are the definitions of rule of law, but original intention of the EU from the point of view of preparing the report on the rule of law of individual member countries was probably different than what it by its historical evolvement arrived today. I'm not going to say nothing that is not generally known, and but from the report on rule of law within the EU Commission became a political document. And I am saying this with seriousness because we had the opportunity recently to be subject of such a report on the rule of law. And unfortunately, it's a political document. It derives through media information, some non-official information from some cheats and false information, and the administration was not verifying this information at the level of official institutions or from official sources, which I consider is a very big problem. Besides that, it was a methodological, not very correctly prepared report, because it was evaluation for 2023. Besides that, some of those things it took from 2024, but not all, but it created in this way not a very comprehensive content. What I was surprised about that the report where the administration of the EU assesses individual countries whether they comply with the prerequisites of the rule of law. Many times there is used the word supposedly. Supposedly it happened. Supposedly it or allegedly this happened, that happened. In a qualified report of such a institution such as EU, there cannot be information that can be confidential. Either it's based on the facts or it's alleged information, and then it cannot be contained in the report, from which there are consequences for the EU member states. From this point of view, I want to state that from this tool of the EU became a whole political issue, which is detrimental, and we should go back to the original conclusion. Thank you. Deputy Minister. As the rule of law motion, I don't have a big problem with the interpretation of the EU, but as regards the results of the interpretation, I would rather prefer its narrow definition, because it's concluded in the basis constitutions of the countries. It's a foundation tool of these countries. So therefore, I would recommend that this interpretation is in its original sense, which doesn't exclude further facts which are not included within the original notion of the rule of law, but are extremely important. For example, the media, or the access to media, the freedom of media, this should be in the narrow interpretation or definition of rule of law, and they were not included, but they are extremely important for the democratic parties' competition, especially in the area of plurality of media, so that they can publish their outputs, etc. The rule of law and the EU operates the definition. It should not be detrimental. However, its interpretation should be narrower, but I do not exclude that the other aspects or facts by which the EU connects it are very important. The State Secretary. To me, seems that we should go back in the discussion why the report was prepared by the EU on rule of law. Not because 20 years ago it was not there, but only in the recent years it is there. But the representative of the Hungarian minister said that it's part of the legal system, and it's the issues of the member countries. We agree that these things should be left to individual member countries, but what to do, what the EU should do if there are happening things like in Poland since 2015-16, when in the positions of the constitutional judges, the government selected 3 judges, when the prosecutor's office is politicized, when the constitutional body, which stands as the protector of independence judiciary. This body is interrupted and there are changed during the term rules, and there are selected members who are not selected by the judges but politicians. What the EU should do, which is trying to be effective, which tried to find solution in the recent years. The seventh article is not so effective so that these detrimental damages can be removed and stopped, and therefore there were searched some more effective tools like report on the rule of law. I would not like to speak about the impact in individual member countries, but I would like to speak only about Poland. And it looks to me that these are not questions that are secondary, but these are fundamental, because the rule of law is the base of our national legislation, national and the legislation of other countries. So therefore we should focus on them, and not only because of the protection of the citizens in individual member countries, but it is related also to the whole European Union and to the unified single market. I will speak about the competitiveness, but therefore there is still a possibility for the audience to ask a question for a short answer. If not, thank you very much for this very fruitful discussion. I believe it will contribute to the conclusions of the conference as a whole, and we will try to be positive. So thanks again for your participation, and namely to the State Secretary of the Ministry of Justice of the Polish Republic, Mrs. Różyńska. Mr. State Secretary of the Ministry of Justice of the Czech Republic, Mr. Willem Anhezenbacher. Minister of Justice of the Hungarian Republic, Dr. Bence Tusson. Mr. Minister of Justice of the Slovak Republic, to Dr. Susko. And to you all for your participation, and I'm looking forward for the next panel after the lunch. Thank you. Thanks to all. I would like to ask the Rector and the Minister of Foreign Affairs to take a picture. And to all of you, bon appetit, and we will meet here at 13:30.
Poprosím už sa pomaličky usaďte o minútku za...
Could you kindly take your places? We are going to start in 1 minute. Bože, to je Zuzana a priezvisko Štúbňa. To je anglické tlmočenie. Máš aj iný jazyk?
Nie.
Ja mám nemčinu ešte.
Dobre, tak ma prezvem, prosím.
Ja sa volám Bratislava Novotná. Nemčina, angličtina.
Tak dovolte mi, aby som...
Allow me to welcome you once more at the plenary session of the Bratislava Legal Forum, Influence of the EU upon functioning and the work of the supreme highest judicial bodies. Now I wish to ask Professor Dr. Vacok to take the floor. Ladies and gentlemen, thank you very much for your nice welcoming. I feel very privileged to be here, to speak here, especially in the judiciary block. I'm also a judge, and it is a close topic for me. The European Union somehow connects us also in this area. Before I ask to speak, my colleagues, speaking about the EU, I recall always my young years. I was born here in Bratislava, and my father has been working with spot sinology, that is canine practice. We have been always looking for meadows. When we crossed the Danube and went to Petržalka, we always met the policemen who forbid us to walk there. Nowadays, after 30 years, I can make a walk there with my children. So today, speaking about negatives and positives of the European Union. European Union has, in my point of view, has changed not only our behavior, but it has changed a lot in our lives. And when I make a bicycle ride with my children on the other shore of the Danube, I hope that my children will not experience it, that what I had, that is, that the policemen turn you away. So it was my remark to the European Union, how I perceive it. Today I can see that the European Union interferes with many areas, social life, legal life, and influences also the judicial area. The next 1.5 hours should be dedicated to this influence. I wish to welcome the representatives of the Supreme Court who are going to discuss. I will start Dr. Jan Šikuta, the Supreme Court of the Slovak Republic. From the Czech Republic, Dr. Angyalosi. If I can tell you, we can look at his CV, but he also spent some time here in Slovakia. So once more, welcome here. And the third member of panel is Mr. András Varga, who came to us from Budapest as the president of the Supreme Court of Hungary. When we discussed, Professor is not only the president of the Supreme Court, but he is also a teacher at the University of Law. So welcome here. You are now at home, also at the Academy of Law, Faculty of Law. I wish to tell you that in the program we don't have here Madam President of the Supreme Court of Poland. She couldn't come for personal reasons. As we were designing this meeting, we set some topics to be discussed. The first is judicial independence, then influence of the European law upon the judgment by the Supreme Courts of Justice, then digitalization and control of the judiciary system. Of course, we will discuss these topics separately, and we will see how the questions will be and whether we can cover everything. So this was my introduction. I am the moderator of this panel. As it was said, I will just put questions now. I would like to ask. We agreed that we preserve that we preserve the same system. That is that each of the judges can briefly tell some introductory words, and then we can have a discussion. So now I would like to ask Dr. Šikuta, the Slovak representative. Thank you very much. I wish to start with a specific theme. I will tell, ladies and gentlemen, dear friends, I was very pleased to accept participation at this panel about functioning of the supreme institutions, because this topic is very current now. In June, there was an opening night of the Slovak film Waves, describing the events, what happened before the Warsaw Treaty, soldiers and troops invaded Czechoslovakia. The film is about a value: freedom of speech, freedom of print, freedom of expression. This freedom is firmly laid down in the Human Rights Convention, along with other rights and freedoms which constitute the pillars of democracy and values of the European Union. These values include also the independence of the judicial power. It is an important and responsible role enhanced by the EU through its bodies like the European Court of Justice, or through the European Commission and its powers related to member states. It wasn't always like that. After the fall of communism, the judicial system had to face the challenges of its past, to apply the European standards in the and application of the European law, judicacy or jurisdiction of the European Court of Justice, and questions addressed to this court. In the past, the judicial system was interfered with by the governments. The independent Court of Justice is laid down in all treaties and of the European Union, but currently we feel it as well. The independence is not absolute because the courts of justice are paid by the government, or when we need some premises, some dignified premises for our courts of justice. There is an effort to control the courts of justice through artificial intelligence, especially when the files are allocated or when the judges are appointed. Everywhere we have the control of the government. We have a court council, European Commission reproached Slovakia that independence of members of the council appointed by the parliament and by the president is not sufficient. They can be dismissed anytime, and they are also dismissed anytime. Slovakia is one of the founding states against the Society Against Corruption, GRECO. GRECO assessed the mechanisms of independence and corruption. The council, the Judiciary Council, adopts the Code of Judges, controls the declaration of assets of judges, and also makes disciplinary actions against judges. And therefore, politicians claiming dismissal of judges and threats to make disciplinary actions against them due to their decisions we can state that the democracy is still fragile. And we have to protect it. We have to start with the judge candidate. The preparation of candidates, judges, is not sufficient. Also, criteria for the selection of the judge. Okay, there are given some points of knowledge, but their integrity, the resistance against pressures, their reactions to situations is not verified for these candidates. And when the character is showed, it can already be too late. Abuse of the powers of the public official can have bad consequences, and also they make a bad image for the judicial system and are detrimental to correct judges. The European Commission in its report was concerned And we share this. We, the judges, we also share these concerns that there is interference with the judgments, with the decisions, then compromising and making bad image by the judges. For judges by politicians, or even changes of the sentences, imprisonment, and also changes in the prosecution, then persons who are prosecuted for the corruption are in the government, are in the parliament, and everything influences, affects the judiciary system in Slovakia. It also makes a bad image for judges in the public. I have to state that such steps are very dangerous. I see such steps as a comeback to the regime which was in the past. There are some states that could be a good inspiration for us. But we have also measures how to prevent corruption in the judicial system, like digitalization and artificial intelligence, then publication of judgments, of course, under respecting GDPR. Then this is how we ensure and can predict the freedom of judges, the right of the European Union through the jurisdiction of the European Court of Justice enhances to ensure the correct processes, and it complies with the standards of the independent judiciary system. But we face a long journey. We have a lot of visions which will be discussed later. Therefore, I wish to thank to the organizers for this opportunity to share our experience and the possibility to get new inspirations when achieving the goals and targets of the democratic society. Thank you for your attention.
Thanks a lot to Dr. Shikuta for his speech. And now we're following the agenda. So, Dr. Anjal Shima. Good afternoon, ladies and gentlemen. As mentioned before, when I was counting fast, 1/3 of my life I lived in Slovakia, and as my parents then decided to move to Moravia, I'm now in the Czech Republic, and therefore there was not missing a lot. I could have obtained the title of Master of Law here in this faculty, but I actually obtained it at the faculty in Brno. So I'm very glad to come back to this place. I'm very fond of this faculty, and it's a very good opportunity when I am invited to participate in such a conference and to meet you and share with you some of my observations from the Czech justice. My speech is going to be about the impact of the influence of the functioning of the law in the Czech Republic on the Supreme Court of the Czech Republic. The establishment foundation articles exist, but they are tacit that these are the internal courts which actually have a difficult role, and they are the central nervous system. So in the current situation of some contradictory legal systems, these are the local courts which should protect the individual. So each member country should contribute by its own legal system to ensure the implementation of the law, which is in line with the philosophy of the variety of the EU. Fulfillment of such a role is determined by the union law, which has some impacts on the enforcement of the law. In the Czech legal system, I would like to outline the three cases. In the first case, we can speak about institutional impact. The European Constitution can only flourish in the conditions of mutual respect and discussion. Therefore, the concept in 2005, with the knowledge of the Czech Republic as the Supreme Court, needs to apply the EU law. There was created the analytics department and comparison department. This department is dealing with the research and comparisons of the jurisdiction of the Supreme Court of the EU, Court of Justice, and in this department, the Czech Republic involves in interinstitutional cooperation. It is an example of law liaisons where there are the chairman of the Supreme Court. This is the group of legal comparatives, and thanks to this cooperation in this group, the jurisdiction and the legislation practice of the member countries is important and allows our judges to fulfill the unified interpretation of the EU law. It enforces and enhances the cooperation within the European system and encourages the trust which is necessary for recognition. The judges also introduce social economic element which involves the internal decentralized powers and cooperate over the framework of their responsibility in compliance with the EU law. And there is the officers for GDPR, which actually ensure the compliance of the regulations and standards. As for the implementation of the judicial powers, we need to look at the judges. The union law introduced to check judges which they need to comply with. So the judges not only need to look at the internal laws but also at the articles of the union law, so that they do not only comply with the requirements of that but also ensure the protection which are required by the democratic state. The content of what the judge should know has expanded so much that we need to be both ways capable. So we are facing the active support to deepen their knowledge, not only through trainings but also through international stages by which they also ensure their international cooperation. Within the network of chairman of the courts, the 11 judges of Supreme Court participate in international stays abroad in countries with different legal systems, from the northern up to the traditional British one. So our judges participated in France, Austria, Great Britain, Spain, Sweden, etc. As for this panel, I can mention that there was a cooperation with the Hungarian partners. Our judge participated also with the European Court of Justice, and others who visited the Croatian Supreme Court, where they exchanged their experience on non-property claims. This is only a small list of what the judges performed that days we are opening also the space for cooperation. In 2022 and 3, we had the honor to welcome the judge of the Slovak Supreme Court. Today we have the representatives of Ukraine. So this diversity is giving us the opportunity for taking experience of good practice from other courts, which we want to apply also in our decision making. The decisions and the common practice is referring to the common law. Referring to the European law is to give reasoning and argumentation more visible and understandable, and to have for readers more reasoning, so that it is more convincing and so that the reasons can be better followed. So there is a judicial dialogue with other courts, and the judicial dialogue and the proceedings are the top of the pyramid of the union law on the institution. This dialogue before the integration meant an integral tool of development of the law. The dialogue between the Court of Justice and national courts is opening the integration. It is the synonym for integration. We need how the law system of EU would look like if it were not involved in the foundation treaties. We could not call it then the Europe of rights and values. So expansion of its with the performance of European citizenship and of the basic rights is also touching the economic issues. And for the Supreme Court, I have to say that our contacts and cooperation with the European Court of Justice is at a friendship level. What we mentioned so far is not going to take us from the important law that are playing the internal courts. The Court of Justice is ensuring the good, correct explanation of the union law. So it would not mean anything if there would not be the national systems which would ensure its enforcement. So if it's contradictory for the authority of the Court of Justice, we need to say that from the Czech part, we make a proactive approach. We are formulating our questions and develop on the jurisdiction of the European Court. The Czech courts proposed 120 questions, and the Supreme Court outed it 16, and the highest court 36. This data could evoke position that we are hesitant, but the number of initiated proceedings is not the only factor which has an importance for the integration in Europe. However, this is more important what kind of cases can be judged by the European Court. For example, one of the contributions of the whole union approach is that there was a proceeding in Vysočina League. This was about the claim by the solar power station wind against the Czech Republic due to incorrect implementation of pollution that the polluter pays. This was about the waste of electronic waste. If there would be proven the existence of the union law, like incorrect implementation of the European law into internal laws, such a breach was excluded, even in case if that would be breached at the norm of higher level. The retroactivity could be explained in that way that it would be necessary for the producers to pay for the waste if they were introduced into the market from 2005, while the deadline expired in 2014. The Supreme Court was not sure about the correct understanding of waste disposal, and therefore it asked to clarify this question by the European Court. Article 13 point one wanted to know about the retroactivity. The really European Court of Justice, it decided it is invalid, that it imposed on the producers to cover for costs introduced before 2005 and up to 2012. So currently it noticed that it before there was by the Czech Republic adopted a legal legislation which is in contradictory with the union law. In order to it was a breach before the directive becomes the part of the union legal systems. Therefore, we should not underestimate it for the protection. In order to ensure the legal certainty for the producers of panels as for dealing with the waste. There was a decision taken with the obligation of the member country for breaching the union law and for using the possibilities that its system allows. The Czech is giving the role of loyal partner in enforcing common values on the basis of which the EU is based, anchored for everybody. So by its activity, the right of the EU, it has its anchor in the EU legal system to be a loyal and partnership dialect which will fulfill the values to which it adheres. The EU law gives us the need to how better to use the system. If the EU law is circulating on its orbit like it would be its own planet, we should try to have some influence of it from our own national system, and we are very close linked to it. I'm thanking you for your attention. I'm looking forward for our next meeting. Thanks a lot to the chairman of the Czech Republic, and I will ask now the president of the Supreme Court of Hungary, Dr. Varga, to give us his introductory speech. Thanks to Professor for my introduction, dear ladies and gentlemen, dear chairman, dear friends, if I may call you so. I am just suggesting that I'm trying to understand your language, but I will continue with the Hungarian language. I'm very pleased that I was invited from the discussion before. I heard we have a lot of tasks and that we are at the faculty law, and I'm very pleased and that I can teach, and I like to talk from the booth. And I am doing that several times a week. I came from a sister university, Peter Pazman's university. They were established from the same root, and from Zeselmayer's university. So we are a greater family that is connected with things there. Besides that they are universities, we have a common history and roots. But today my role is to talk about a concrete topic. We need to analyze the impact of the EU and the membership on functioning of the Supreme Court. As I am the person from academic environment, I need to have 90 minutes limit. From that 80 minutes would be the history of the judicial system. The next 30 minutes I would be dealing with mapping of certain stresses. That was in German. I will jump that, but so I will stay with 1.5 an hour, within which I will talk the most important developments and facts about the argument of and conflict of Luxembourg, but you know about it. But then there are left 10 minutes. I have used already half of it, so I will stay with the time to formulate some questions for which we do not have answers. So I would like to ask you that what I will say is perceived in this context. So for what we have answers and what we have in function, I'm not going to talk about it, it's clear. And my speakers already said that. But where I can see problems there, or in that European law and the law forums and forums of the member countries were created on parallel relations. That means each has its own area where they can say their last word. And in order that this system functions, the European Court, Strasbourg, of course, the European Court for Human Rights, and the constitutional courts of the member countries, and in most cases, also in Slovakia, the Supreme Administrative Court, each in their areas of competencies, ensure that the position of a legal institution. And in order that it all functions, we need a dialogue between such institutions and the European Court. But recently this constitutional dialogue has changed a lot, and therefore I'm formulating it in that way because I was invited as a judge. If I would speak here as a pedagogue, I would formulate it in a different way, more strongly. But there exists a concrete moment to which I can link it. And a Romanian court decided preliminarily and it approached the European Court and asked that he or it, as the Romanian court, whether it is obliged to comply with the interpretation of the Romanian Constitutional Court, which is applicable for Romanian courts if such a decision is contradictory to the European Court's decision. So there was no doubt that if they asked already, so the European Court will say no. But it said actually that a regular Romanian court is not obliged to comply with the interpretation of the Romanian Constitution. I would like you to think deeply about it because it looks like that the interpretation was transferred to a different level. Of course, you know, I'm not going to say this is Van Dengen case. It cannot interfere with European decisions and other decisions that the constitutional courts cannot, in case of transferred competencies, cannot influence. But you know that. But the constitutional court couldn't have decided and should have declined. This is a new approach with regard to this. It is problematic. I can say only one argument that by this decision there ceased to exist the equality of courts. We started to go through a way when the Luxembourg court is behaving to Supreme Courts or to constitutional courts of national countries as Supreme Courts of member countries to the courts of lower level in their member states. And this is also reflected in different documents, but recently also the European Court started to underline that the Supreme Courts in the member countries, one of their tasks is to ensure the unified application of the judiciary. That means there should be unified application, enforcement, and after that, Luxembourg admitted, and its role is to ensure unified application of the European law between or among the courts of the member countries. In order to simplify, the Supreme Courts and Constitutional Courts are not on the top of the pyramid. They are not anymore the most important ones. In relation to the EU law, such courts are not in that position. And why? Because here played a role, another factor, concretely, the Human Rights Charter, because by approving the Charter of Human Rights, actually all competencies of the member countries can be transformed into common competence of the so this charter actually dissolved the difference that there exist transposed powers performed jointly, commonly, because according to the charter, such basic rights are common, unified. And in this way, there was offered to the European Court a position that there exists the Supreme Court and there exists a Supreme Court. We could say this is a theoretical question, but unfortunately it's a practical question, because if we think about that, what you know, that each court has a right to initiate the preliminary decision with the European Court, where in the end it will lead, and I will simplify it, and in order to finalize, it leads to that the Supreme Courts of the member countries can be bypassed. I cannot get rid of the feeling that I'm at the law faculty, so I'm asking, frankly, you should ask yourselves and answer as well whether there is a need to have national courts and whether there is a need to have a Supreme Court. We can say our own answers in the discussion. Actually, we will also develop on that, but I would like to conclude my speech by that despite of that you think that this is a very fast process, that we should somehow slow down, so that the Supreme Courts and Constitutional Courts have some function in the future. So I see it as a solution that there is cooperation with the Supreme Courts, Administrative Courts, and Constitutional Courts. In brackets, I note that we already saw that all this was created on the basis of some tension between the national courts in the country, so end of bracket. So I can see the solution in the systems where there is an institute of constitutional complaint, because in such cases the constitutional courts can apply the constitutional right, because if there is a seizure of the decision or cancellation of the decision, it can arrive to a proceeding in breach of the obligations. So this is another topic. So my question is where I can see the way out and the solution I can see in a dialogue. I would not mind if in the future the Supreme Courts and Constitutional Courts of the member countries would have their own role and meaning. So by that I would like to conclude, and thank you for your attention. Thanks a lot also to the third speaker with his introductory speech, and now we are going to start with the discussion. We will follow the order. So we will start with the justice independence. There were many questions, open questions, and I will start the question to all speakers. how do you perceive from the independence of justice and the membership in the EU, whether the membership in the EU contributed to enforcement or weakened the independence of internal courts or internal institutions? Thank you. Yes, please.
We cannot hear him, sorry. Could we get some help? I can give you my microphone. 20 years ago, Slovakia and Czech Republic acceded the European Union. The world opened to us earlier. That was enough for us with our jurisdiction. But as we joined the EU, we adjusted our legislation. That means that we changed our legal norms and rules in compliance with the EU standards. What influenced that our legal order was changed, and our task was to implement it. Our joining the EU, I don't think that there was any special influence from the part of the EU, because we have to comply with our legal system, and we just apply what the EU required for us to join the EU. Of course, there are some exemptions that the national courts of justice make a decision, and when the disputes end in Luxembourg or in Brussels, then there can be some different opinions. As we heard today in the morning, that when two lawyers meet, we have at least 3 legal opinions. So there are various legal opinions and ideas, and 2 courts of justice do not have to have the same conclusions or decisions. But I don't think that the EU, not only in the Czech Republic but also in other member states, that the courts of justice would become less independent. Thank you. Thank you. Like President of the Supreme Court, I do not see any discrepancy, because the goal is, for example, the Slovak Republic and other V4 countries wanted to join the EU. It wasn't the will of the EU. We wanted to join the EU. Why? Because it was about the European values. We wanted to share the European values. I can recall it very well, this accession process in the Slovak Republic. I was abroad at the time, but I can recall that it was a complicated exercise, and each of 10 candidate states had to pass the harmonization process. So it means that that was the goal, that within the EU we have one compatible space where similar or the same values are shared. When speaking about the area of justice, it applies the same, because justice is a part of the society. The decisions of national courts, that is regional and other courts, the decisions should unify the jurisdiction. They should have a very similar judgments or decisions. So it means that in this supranational area where it is expected that the national courts, even the Supreme Courts, will rule so that the European space would judge in a very similar way. So I think it was enhanced. The EU membership enhanced the position of the courts. I don't think, it is not my opinion, that the national courts want to make different ruling or decisions. If we want to share one area, we have to have the same values and the same ideas. Now, I would like to ask Dr. Matka. Unfortunately, nerozumiem. Nejde to prepnúť. Really, our independence wasn't influenced thereby. Regarding to our intention to join the EU legal system, this intention was very influential. Both presidents said it. Between 1991 and 4, all three countries decided to join the EU, but there were some formal criteria and we tried to meet them, to fulfill them. What had an influence on us? We were close to this previous regime. When I attended a conference in Prague, I said that the illustrations were made in these countries because the changes were made on consensual basis. The political elite governing at that time wasn't guaranteed. I don't want to tell whether it is good or not. It was also in Hungary. I fully agree, and I fully agreed that unless we had a general illustration, simply it was forbidden to to touch the jurisdiction. And maybe there are some people who can recall that Mr. Scholz, he was the president of the High Court. He said that if he wasn't checked by politicians, it had really an influence. And the power was changed without any constitutional basis. Such judges who were considered to be independent really became independent. And it was necessary to mentally get to the previous status. And in this part of Europe, not 20 years ago, we learned what it means to be an independent judge. In this part of Europe, there are very old laws going back to 700, 800 years, which excluded that the judges could act on their own. So we knew that independence is not a privilege, but it is an order. For me, as a judge, it means that I have to be impartial, that both parties of the trial have a chance to win, and the rest were forbidden to interfere. So for me, it is an order that if somebody became a judge, then he wasn't criticized and interfered with. Of course, we can criticize the judgments, and sometimes we make some conclusion or decision, and tomorrow we state that we could have decided differently. So we cannot attack the judges as a person. That what was brought by the EU meant that there have appeared things which did not exist earlier. For example, For example, there are some differences between our judicial system and corporates of judges. Thank you very much. So I would like to put a question which was already discussed in the first panel. And also Professor Varga asked it. When we have today the system of the European judiciary and the system of national courts of justice, from your point of view, what would be the ideal communication and relation between the EU and national courts? Should it be this partner model, or should we decentralize more? Let me start, as it is interesting for me, and I appreciate these topics. The first panel was discussing, in my opinion, is we don't need to initiate decentralization, but it is necessary to examine the relation. We personally paid a visit and spoke to President Lenz, and we discussed a lot. And I agree that the system of courts of justice should be viewed and imagined like that the Supreme Court, the National Supreme Court, and the partner of the Supreme Court is the European Court of Justice. Constitutional courts have a partner in Strasbourg. And especially we have to communicate with the high courts, with Supreme Courts, because these courts give preliminary questions which are very important in order to achieve harmonization, unification in the interpretation. So I don't think that we have to see the contradiction between Luxembourg and national courts, vice versa. The national judge, in a close cooperation, as it was said by my Czech colleague, that they had very good and friendly relations. That means that we should communicate in the interest of a citizen to enable him or her that predictability in order to secure that what the judgment will be. And here the very good communication between national courts and Luxembourg court is very important. My microphone works as well. I would rather ask if the national court wouldn't cooperate with the European Court, then there will be different judgments. Will be these judgments convincing and trustful? It is the same as if there were courts of justice, local courts, without respect to other national judgments. So as we apply it in the practice, I have been working in the justice for 30 years. In the past, some Strasbourg decision that I would apply it in the reasoning of my judgment. In the past, I didn't know what the internet was. To get the judgment from Luxembourg or Strasbourg, it would have been a miracle. I would have to travel there, or I don't know whether I would find it in the library. So, as I said it already, the fact that today we work with the European jurisdiction from Strasbourg or Luxembourg, it supports our judgments, because our judgment was made in compliance with the union's right and law, and it also enhances our rights and judgments. We are not an isolated island. The member states are not isolated countries. We joined the EU to join the EU, to enjoy the same values, to enjoy the rights and benefits of the EU citizenship, and that we will abide by the European law. Therefore, we approximated our legal system to be able to become member states. And the media misuse it because they don't speak about the benefits. They just show some negatives, that we have to be obedient to that what the European Union says. But we accessed the EU voluntarily, and we share the European values, and therefore our judgments refer to the European Court of Justice, and therefore our judgments are more trustful, because it is clear that I comply with the European law and I apply the European law to the local law and judgment. So it is very good for the trust of the public. I prefer, as my colleague said, I think that the partnership is important here. And the European Court with the European Court of Justice, we have been keeping very good relations. We cooperate together, we communicate together. So at least the Supreme Court of the Czech Republic, we have an excellent communication relation. We are in a direct contact with the President of the European Court. We know each other personally. We even consult jointly some legal topics. We want to hear our opinions, so it is a really very good cooperation, and I think it is right so, because this is how the European law can be, as I said, by preliminary questions. This is how we share the opinions and judgments of the Court of Justice of the European Union, because they want to apply the European law. They want to show us the trend. And the way what we ask or what we draw attention to when we tell our opinion, they consider it for their ruling. It is not that they would follow our opinions, but anyway, it is an enhancement, and it is a mutual cooperation between us, which helps. And I think that this makes us more trustful in the public, because when a party at the court reads my reasoning, and which is full of references to the judgments or rulings of the European Court of Justice, then it is clear to this party that I respected in my reasoning and in my judgment the European law, and therefore it is clear for this party that he cannot appeal or shouldn't appeal to higher courts at the European level, because he can see so that that I complied with the European law. Thank you very much. I wish to tell you that we keep very good relations with the European Court of Justice, with Mr. Lienarts. We communicate a lot, and together with other judges, we awarded them with prizes. The question is not whether we are friends, but we speak about many questions. For example, powers and competencies. I cannot speak on the basis of emotions and belief. We don't have a time to deeply discuss these issues. Of course, there are differences. Regarding to European ruling, there is no discussion. The European Union sets the rules which has to be applied. And the European Court of Justice lays down the compulsory application. It is no matter of discussion. There is a different situation in the directives where the European law enables more or less space for states, and if this space becomes narrow, there appears a question whether the Court of Justice should convert the directive to the order through the interpretation. I don't want to speak a lot. I don't think that for Slovakia this issue is not so decisive or interesting because you have the currency of euro, but in the Czech Republic, Poland and Croatia, when paying back credits taken in euro, there is always a question, and there is no directive about that. And national courts of justice only gradually start to put this question in Luxembourg. And now we gradually get to the fact that it is necessary to bring a uniform decision without a compulsory legal basis. So it also refers to us. So is it really without problems? And what I keep asking is which role is played by us as the Supreme Courts of the member states? Are we the transmission? Are we the channel through which the European law runs? Well, it can be applied also without us. There is a legal unity. Therefore, for our next meeting, I would like to speak about that if it is able to avoid it through precedence system or to achieve some limitations, because before you start attacking me, and I know that here is some exit, so I can run away, but we have to answer why do we think that the European Court of Justice remains without doubt, although decisions and judgments made by our Supreme Courts are somehow not very much agreeing that it should be these should be precedents. I will answer all questions, so don't be afraid. Thank you very much. I wish to continue in questions. When we take the European Court of Justice, it is bound to the actions of judges of local states, because if they don't show the activity, then the European Court of Justice will not answer. We have judges in the administrative court or general courts who put a lot of questions, but we have also judges who have never put any question, and the discussion running between us, where is the ratio, where is the time when the judge should tell himself whether he should put this question to the European Court of Justice, and when he should put this question and where not. So how do you understand it? When should we contact outreach to the European Court of Justice and when not? Because it is sufficient that what we have.
Proces.
It is a process that lasts a time. I remember when Czechoslovakia and then Slovakia acceded the human rights treaty, the judges didn't have a knowledge about the treaty, how to apply individual articles into the treaty. We need to understand that the national judge in one moment had to deal with many information. After 1990s, there were changed laws, there were created new disciplines. Czechoslovakia became party to the treaty. There was applied the new jurisdiction, and there were a lot of information. And as far as the European Union, the one judge had too much to do. I want to say that it is a lengthy process because as in the 1991, the judges did not use in their argumentation in decision making. And now, after 20, 30 years, there are judges who are using the decisions of the European Court, and we still have some judges that they are fine and sufficient with the national laws and their interpretation or jurisdiction of the Supreme Courts. And therefore, also, it relates to the question, when there is the moment, when the judge understands that he should already pose this question, with the number of knowledge he has, if he doesn't have this number or pile of knowledges, he doesn't know that he should ask this question. And the judge, who is well-oriented, who knows the jurisdictions and knows, yes, this is a thing for which there was not given an answer yet, he will pose such a question. So my answer is, it is a process, and with each judge, it takes differently. A judge in pension, he says, I am not going to learn this, it's not any more interesting for me. The young judges, they have a whole career ahead of them and they are interested. And then there are in middle-age judges, but it's a process that lasts. So it is not possible to answer when there is the time. When the judge feels, yes, it's the moment, and I should have a pile of knowledge for that. As we said before, the Czech Republic submitted 125 preliminary questions, and the Supreme Court now has 2 with the European Court, which are not answered yet. It's about that as my pre-speaker said, that it's about knowing the knowledge of the judges and how much they know about the European issues today. Thanks to that we cooperate with the European Court of Justice. Last year we had one colleague there in a stay. So the cooperation and the contacts are active, and the judges of the Supreme Court get closer to these issues, and therefore they are more open to the possibilities, and their eyes are more open, and they have a better overview of what questions they can pose to the European Court. In his career, one can have such cases that there is no need for him to give a preliminary question to the European Court of Justice, because he is dealing with cases where there is no need to question something, but it depends on concrete cases, and not only Supreme Courts ask questions, but there are also courts of law, for instance, which ask questions. But the understanding about the EU legislation, about the decisions of the European Court is increasing, and we, in 20 years' time, when we meet here, we can say that the Czech Republic for the last 20 years has posed 120 questions. Maybe in 20 years it will be not only 120, it will be many more. So actually, how much it is in the knowledge and awareness of the judges, the awareness is getting broader, and these questions will be asked more and more. If I may to add, what changed is the awareness of information. The awareness today is quite good as regard the jurisdictions. The language barrier is getting smaller because more and more judges speak a foreign language. But even if not, in the Supreme Court, we have a documentation center that is dealing with that. We have contracts with SAD, SLP. We have jurisdiction, which is translated in Slovak. So the barrier for information awareness is much lower than 20 years ago. Thanks. I fully agree with the chairman, who are my three speakers. Yes, of course, I cannot say with any of the initiatives anything else. You need to approach the European Court of Justice with a question when there is a need that such a court replies to us, and it is a process within which we are learning. There is no contradiction among us. We know GSF one consortium, so we know these frameworks, and we need to approach the European Court of Justice when there is not clarity. And here start problems. If somebody is a Hungarian judge, here we have such a logics of the language totally opposite. I don't want to say that the language translations are not trustful, but there are differences in the tones and some meanings. It is slightly different than the Slavic or German languages, Germanistic languages. Before they attack Luxembourg, they should read as much as possible in many languages, so that they read at least in two languages something. And if they cannot understand two languages, they can ask colleagues who do understand. So we provide to colleagues, if they need language help, we do provide such a help. So it is not necessary to run immediately to the Court of Justice. If there is no answer at all, I can show you some examples that behind the question is usually that we ask Luxembourg court, forgive me, that for such a salary, for such pay, am I sufficiently independent? It's strange. Or these are concrete things. When the Supreme Court decides that a certain decision needs to be implemented by a lower instance court, and at the lower instance they ask whether they really need to implement the decision and execute it. So at that time you need to approach the European Court of Justice when we really need an answer from this court. Thank you. Of course, this is a topic that there might be a lengthy discussion, but I would like to end the topic as we are moving with the time. So I'm asking whether by the impact of the European Union you have the feeling that there intensified the cooperation at the level of internal courts. Mr. Chairman, you said that there is active cooperation within the Supreme Courts. So how do you perceive the cooperation of the internal courts, whether it's getting more intensive, and how do different judges use it at the Supreme Court level or lower instance level? I believe you mean cooperation of the national courts at different levels of courts. Yes, yes. Of course, we always had some competencies. The Supreme Court unified the jurisdiction, the decision making practice of lower instance courts. So I did not note any major problem in this respect, that the lower instance courts would not accept the decisions of the higher instance courts. there might be a judicial ping pong, but these are unique cases, seldom cases. If you take that the Czech Republic has 11 million inhabitants, 1,000 judges, and each year he has about 600,000 new cases. So if even 10 would be in the judicial ping pong, this is only a negligent amount. And it doesn't have to be necessarily by that some people, judges are stubborn and do not want to accept the legal opinion of the Superior Court. I remember case that I had some polemics, but I accepted the opinion of the Supreme Court regarding VAT rate in one tax crime, whether the coupons for charging mobile phones, if somebody sells these coupons and if somebody buys such a coupon, whether he's buying a service or he's buying goods, the card with a certain amount of credit. There was a different rate, whether it's 5% rate or 20% rate. This was an issue that we clarified, and we were of the opinion that he's buying the goods because it's and the Supreme Court and Mr. Shamal, my predecessor, the chairman of the Supreme Court, he had handled it, and he arrived to the conclusion that it is a service, it is not a goods. Therefore, there is the lower rate of VAT, and besides the damage like 500 million Czech crowns, there was a damage only 120 million crowns. So it didn't have impact on a case as such, because the fine was there, but he got less years of imprisonment. So this actually may seem that it is judicial ping pong, but it's only about maybe case that we are needing to clarify some things. And from this point of view, when we look at the decision-making practice of the courts, I didn't note that there would be a problem in the Czech jurisdiction, that there would be some discrepancy in decision-making practice. We as the judges want to react as fast as possible. There is found out that the judges and courts they do not apply something correctly, that they do different interpretation. In the COVID times, and as I am a criminal judge, we can say that there is a recidivity of theft if you just steal a thing with a lower amount. So you, as a recidivist, you get a higher penalty. In the times of COVID, it was in the times of impairment of the state. There was an extraordinary situation. So besides the second article, it's the fourth article, and there is a more strict penalty. And some courts automatically looked at it, that there are strict limitations in COVID. There is extraordinary situation, so they applied the fourth section, and the penalties were draconic. But others, courts in other parts of the Republic, I mean the district courts, they said, okay, that we don't need to consider something else, because if a person who is a perpetrator and repeatedly steals chocolate or a bottle of alcohol, it's something the same and doesn't influence whether there is the emergency situation of COVID or whether there is normal situation. In that case, we very fastly, within our Senate, when we had a first case with the appeal, we very fastly adopted a decision of the big Senate where we explained what needs to be considered in such decision making and what needs to be considered also, that under which conditions, even if it's a repeated action, that whether the extraordinary situation with the COVID had an impact on it, and if it allowed or eased up this theft, like stealing disinfections, whether that would harm delivery to a hospital or house of people where this supply was determined, or whether this was a simple theft of chocolate, or whether that it is impacted by the extraordinary situation, I mean, what the conditions were. Yes, in that cases, if it had to do with that fourth article, yes. If it was a classical theft in a supermarket, that he stole only a bottle of vodka without paying, this had nothing to do with the extraordinary situation, because it had no impact of extraordinary or no extraordinary situation. So there are no other conditions that are added to that, and then there was applied the second section. So we unified the decision-making practice, and then we could see that not only the accused we also, our courts awaited this, what needs to be considered, and for the correct decision-making. So the unification role is very well functioning, and I never crossed the situation that there would not be a unified decision-making practice. A short note, the question was on cooperation with the internal courts. Yes, it had some impact, and it has some impact because these are new things, and also in the past and today there are meetings between the regional judges. I can see here colleagues from the Supreme Court, and the cooperation is very good. The reply is that there was a need developed to answer also questions that were related to the European legislation. Professor? I would like to give you a short story. I would say there was the 50th anniversary of a couple of married, and they asked them, "You really love each other? If we were not loving each other, would we be here?" And then they asked me, "You never quarreled during 50 years?" And the question, would you have suffered such a terrible person without quarreling? The fact that there are quarrels, that there are conflicts, it's a normal part of the life. A judge was never born who would be happy that if his decision would be cancelled. I don't like as well when the constitutional explains to me that I don't understand the law, but we do not like that. But the sun nevertheless gets out in the east the next day. So also the boxer sometimes has to live with that he gets a punch. By closing what I had already ready for the first part, I would stop the discussion and give a possibility for the audience if any question is there. And then Mr. Trenchon. Good afternoon. Mrs. Kofis, I'm the chairwoman of the Court Council of the Slovak Republic. I heard that the chairman of the Supreme Court repeatedly said and mentioned the Council of Courts, and maybe there might be an impression that the Council would be criticized that into the systems is entering not very good quality judges. I have to react on that. There are many members of our Council and of our courts. I will react to that the court counsel within disciplinary actions has the right to split it into the small cash. The proposal for disciplinary action against a court can be submitted by the chairman of the Council of Courts and not the whole Council of Courts, and there is no force for the core council to force the chairwoman to submit it. And when the council arrives to that we already stated that the judge didn't prove that he had obtained his property in a fair way, then the chairwoman is obliged to give a disciplinary action that it is in contradiction with the functioning of a judge. Mr. Chairman, you said something that there are not checked the judges, their integrity. You need to look. We have a paradox in our legal system that less important the selection process is to the Supreme Court. Several days of mass selection is for the first instance judges. It's very difficult, and there are very many percentages of losses. I used to be a chairwoman of those selection processes, and these are sometimes very tricky questions there. So that the Council of Judges is verifying or not verifying within its law responsibilities, and if the council that go to the higher court, they go through a difficult check. We have established by law and by constitutional department that ensures a huge number of documents in order to find out about the property of the judge, whether he is linked with organized crime. It is a section of search investigation, and therefore they can look into our lives, and the results of such findings are submitted to a control committee. Such a control committee can ask the judge, communicates with him, and the whole Judicial Council asks the judge. So the property report is submitted each year. In 92 or in 2022 or 3, I wrote a reaction to the report of the EU that it, I think it reacted to the Constitutional Court decision and allowed to look into the property investigation, but only in cases of disciplinary or criminal law. But we, for many years, have a public record of property of each judge. And who knows the Slovak language, he can obtain all the information. I don't think it is very good to talk about such a thing that there is not a good system. I think our system is a very strict one for selecting the judges. I needed to speak about it because the Council of Judges is part of the national area, and we are also with the Hungarian Republic in the European environment. We actually established the bilateral cooperation after our General Assembly of the European Councils of Judges, and we are going for a visit to Budapest. We are looking forward for that. And when we talk about the European area, I, as the chairwoman, had to react so that it doesn't, it is not interpreted in a different way, but the council responsibly performs its role in selecting the judges. Professor Jajak also went through this selection to the highest administrative court. And as regards your final words in the discussion, we talked about the cooperation of the internal courts here. Also, the council of judges supported the decisions of the first instance and the regional court, so that the district and regional courts and their judges have access to the decisions of the Supreme Court. And we were trying to protect these judges so that they don't have to wait for the unification standpoints or opinions, but that they can work with them in some legal issues. That much from my side. Thank you. A short reaction. I'm sorry if it sounded like that, because I was not criticizing the council. I lived the system of preparation of judges through justice candidates. That I wanted to say that there is not a very good system of preparing the candidates for judges. I went through the system at the times of socialism. It was very difficult, complex. You know that we were 3 years in preparatory phase. Today, there is nothing like that. That's what I meant. I didn't want to criticize. I'm sorry for that. Mr. Angaloshi, one idea on cooperation between the individual courts and transparency in decision making. There are lower instance courts, and they have the possibility to see and find all decisions of a higher instance court, because we are publishing them. And besides that, maybe you know the green collection of the decisions where they were originally printed. It was only for preparers. It was quite costly, and I 2 years ago managed to implement that. It is in electronic form, and it is for free for everybody. So anybody goes to Supreme Court's website, there he can find the decisions of the Supreme Court. This is whatever was in the green collection. There are selected the most interesting decisions of contradictory cases, and into this collection, what is selected is that we have many comments, and the comments are then adopted, like law faculties, ministries, where we send them, so they can comment on that. So the academic floor can express its opinion on some decision, whether it's correct, whether it's useful, whether they see it as useful to be published in the green collection. So it's not our own will that we will publish this or that, but they can influence the process of selecting these decisions, like the Chamber of Attorneys, etc. So once it is in the green collection, the decision is published on our website, and it's free for everybody. And it supports the awareness for the public, for the courts, and for the attorneys, so they can find available these cases. And besides that, there are also common decisions published, and they can be also published, but the judicatory decisions are available freely, so that we unify the practice and that the courts can communicate better between themselves. In order not to forget, Professor Varga wants to react. Thank you very much. We have one journal which is 70 years old. The journal has 70 years, and it has a selection of the decisions. Today it has a secondary importance, and it's only on our website, because since 2012, for 12 years now, the Supreme Court of Hungary
all decisions in anonymous form is publishing on the website. These decisions are available for everybody, and many decisions of courts, like the appeals against a decision in first instance court, has to be published. So if there is an appeal, then there is a need to publish also the second instance court's decision. So in anonymous form, there is a whole pile of decisions available. And moreover, this anonymization is performed already by AI. It's a role of the chairman of the Senate to approve this electronic procedure, but the computer gives a signal where are the places where we need to make it anonymous. And in my presence, there is also the General Secretary, Judith Jarmati, who can confirm it. And now it is a problem that in this collection there are too many decisions, and it was not invented yet how they can exist, how green or red decisions can be started to exist, but we have quite a good base. So thank you for your question and reactions, and now I will ask Dr. Trenchan from the Supreme Administrative Court.
Unfortunately, the interpreters cannot hear a person speaking without microphone. The question, I will not burden you. In the morning, we heard that through the EU law, we get here American precedence law. I would like to know whether you agree with this opinion, and if it is a problem in your opinion, or vice versa, whether it is a tool to enhance the legal security. Thank you. Please. Yes, I mentioned it as well. I also said it, and I think that it is necessary because our legal systems are adjusting, and the judicial bodies in Strasbourg and Luxembourg took over the French system and also the English system of precedences. And I think it was necessary to get these elements into our legal order. Of course, we cannot take over the English legal system so as it is decided there, because, well, there were many publications issued that this is a multiple layer, and this legal word and jurisdiction cannot exist without English precedences. This is my idea. It has not been scientifically proved. Thank you. Whether we want or not, the judicial system contributes or is a certain guarantor of predictability and legal security. I can only join, as I have the same opinion as my colleagues have. Yes, there is a difference between the English legal system, where the judge creates the law. We on the continent, we only apply the law. This is the basic difference. But we have to understand that our legal system is not completely without precedences, because we apply precedences in our practice and we recognize them, because it is clear that when I get the judgment made by the Supreme Court, so I can take it when I am a judge at the regional court. And just for the reason that if the party appeals against my decision and goes to the Supreme Court, then the Supreme Court would return me the judgment. So we acknowledge, we recognize several principles. It is so precedences, and English law is nothing new for us. This precedential law is also present here on the continent, even not so much as it is in the UK. We can see the opinion on the legal issue. So I, as a judge, as a regional judge, I should abide by it. Yes, so judicial creation of law. When you take the civil order, there it is, then it is really stated about the law and right of the judge. Nepočujem. Sorry, I cannot hear. Let's imagine when we take a lawyer and he has visitors, and he will tell, dear client, we can win this trial, but it depends on then whether this would be judged by Judge Chikuta or by Judge Varga. So I can tell that it is not absurd. I can give you an example, which can happen in any country. Professor owes me €100, and I would initiate a process, but only for €10 because the fee is very high, and the other €90 can be then the object of the trial, and it is decided already. And I would ask, can I apply this judgment without the judgment has been made? The half of the Senate said that this is a matter which has already been decided. But the other half of the Senate said that the judgment didn't refer to the €90 and that something must be done with it. And the Supreme Court is at the end of all these procedures, especially when it is a trial where big sums of money are being decided. We cannot initiate a process which takes 2-3 years, so we cannot just throw a coin and decide against or again according to which party this coin falls, until we establish a nice interpreting precedence. But it would take a lot of time, because we don't have Harry Potter's magic capabilities, but the system can be stabilized. For us, it is important to have a stabilized system, like we do not have the privilege, the independence of the judge. So we all the cases of our clients are always a toy for us. So we are in delay. Regardless of that, it is not very frequent that we would have here 3 presidents of Supreme Court. So please give me your question. Thank you. I would react to the morning panel and the current discussion. I would like to go back to the cardinal problem between the European and local law. In the morning we had here also politicians. The basis of the problem is that the member states, according to their constitutions, confer the part of their rights on the European Union. As the European law has been developed, there is that. Or some doubts about this, where are the limits between the powers of the European Union and the Court of Justice of the European Union and the local or regional courts. And later on, we hear that everything is determined by the European law, and our national law is subordinate to the European law. I think that always, like in federations, it is important to differentiate the competencies. That means that which conferred rights were conferred to the European Union, where is the area which has to be transferred to the local legal system. There should be some freedom. It should be more free, and in this area we can ask about the interpretation. These questions are then put to the European Court of Justice. Of course, the member states is responsible for the transposition of the decision of the EU to the local level. That what we have said may be obvious, but also without the change of rules, it is necessary to differentiate what is going to be controlled by the European Union and by the local courts of justice. The Court of Justice of the European Union is expensive. It is not so unambiguous. There are some concerns like internal security and free movement of persons, and from this point of view, the European Court of Justice has to decide. It shouldn't be very expensive, because if it is too expensive, the member states can have concerns about their rights and powers at the national level, and this is how the problems arise. Please don't take it as a criticism of the European Union. I'm speaking about it that in order to prevent the anti-European moods. But then there are tendencies which can be detrimental, like Brexit. The European Court of Justice should recognize that the basis are the member states, and the European Court of Justice just decides that what was conferred on it by the member states, and that during interpretation it shouldn't be too much extensive, because then arises the problem. A couple of time ago, there was said as a joke. There was a discussion whether it belongs to the European law and whether the European Court of Justice could present its opinion. But generally, we thought that it doesn't belong to the powers of the European Court of Justice. But the official said that when we asked the European Court of Justice, then the European Court of Justice says always yes. And this is how we could solve it. So I think that that the European development could be damaged by this. Also the Constitution. When we candidated for the Constitutional Court some years ago, and already at the time the appointments were not very transparent, and I think that this attitude has not changed so far. I think that the constitutional courts should protect it because the Constitution says that we confer the part of our rights on the European Union, and we also adjusted a part of our own legal system. That means the Constitution played the most important role. And if it is necessary to fulfill some commitments towards the European Union, then it is necessary to strive to make a change in the Constitution. It is a role of the national parliaments. But from constitutional courts, we cannot request from them to take the Constitution out because the Constitution must be respected. Thank you very much. Before I ask my guests, because we do not have a lot of time, does anybody have any other question? But I think that we could even drink coffee, but perhaps I would like to ask our colleagues, or if you wish to say something what has not been said. Libor, it was Libor's remark. I don't think that any answer is necessary. Yes, Libor, it is like you said. Yes. So I don't know what should be the conclusion. Maybe that a cup of coffee during the break. I can only thank to all the public. And I believe that we can speak further on in the evening at the ceremonial reception. Thank you very much. I would like to thank that it was a pleasure to meet you here and to speak, to share my ideas. I hope it wasn't the last time. Of course, I look forward to another Bratislava Legal Forum, and I believe that we can cooperate further on. And I will always be happy to return here. Thank you very much. Thank you. Ladies and gentlemen, at the conclusion, I wish to thank to the organizers that they organized this panel, which is very exclusive and very new. I would like to thank to the guests invited that they found the time for this discussion. I would also like to thank to all participants of this forum. At the conclusion, I would like to tell that all of us have some professional role, but the academic area is the area where we can leave the professional role and discuss freely. So thank you very much. And I'm not concluding this discussion because a former teacher of mine said that that we cannot finish the humanistic topics, but we can continue them. And I also believe that we will also discuss these new topics in the future. Thank you very much, and enjoy your coffee and refreshment. Thank you very much. Dear participants of the panel, so the coffee break will be prolonged to 4 p.m. Then I would like to kindly ask you to go back, and we will launch the third discussion, 20 years of advocacy in Europe. Thank you very much.
Dovolte mi vás
Allow me to welcome you in our last panel of our plenary session titled 20 Years of Advocacy in the EU. By this, I would like to pass the floor to Mr. Laciak, the facilitator of the discussion. Ladies and gentlemen,
just very briefly, and then we have very good interpretation. I would like to appreciate really interpreters that are really professional. So although my moderator skills were prepared for English, I will start then in Slovak. But first of all, allow me to welcome our international guest, that's Mr. András Secskay, the Vice President of the Hungarian Bar Association. Mr. Martin Puchala, who is the President of the Slovak Bar Association. And I would like to excuse and explain why we are not appreciated by attendance of two other international guests, Antonín Mokry, who is the President of the International Section of Czech Bar, because he got sick during weekend, and Mrs. Katarzyna Gajovečník-Puščina, Deputy Dean of Warsaw Bar Association, excused her participation only on Friday. So I'm very sorry they are not here, but they are excused. Teraz prejdem do slovenčiny. Čo sa týka témy dnešného...
Now I will move into English. As regards the panel, it's 20 years in our EU advocacy. This is the main topic, while the subtopics are interconnected, and the whole presentation will not be split as it was in last panels, but we will naturally connect them. But the topics are the free movement of advocates, lawyers in the voice chambers in V4 in relation to EU, and a key topic, liberalization versus regulation and quality, and the role of attorneys, whether the attorney as such should be regulated by a chamber or it should be a free trade license. And another topic related is the ethical dilemmas and issues that relate to performance of the job of attorney in providing the services and within the position of the law attorney himself. So let me pass the floor to Mr. Puchala, the chairman of the law chamber. Dear Mr. Minister, the Dean, dear colleagues, first of all, I would like to thank the University of Comenius in Bratislava and its law faculty for the opportunity to have the word at this important forum, and thanks that the Slovak chamber could be a partner in such an important event, the occasion of the 20th anniversary of acceding to the EU. I'm very happy that we have here a colleague from Hungary. I'm quite sad that our colleagues from the Czech and Polish Republic could not attend, because anything like what we want to initiate, like change of legislation or a legislative draft in regard what we want to be advised, many steps first lead to Prague, that we get inspired, and then to our next neighbors who are also an inspiration for us, and I am very grateful for that to all of them. As the chairman of the Slovak Chamber of Attorneys, I can see a very big importance of cooperation between the chambers. The Slovak chamber, as the other chambers of the neighboring countries, has been institutionalized because we are also the member of the councils of Chamber of Attorneys of Europe. And I cannot imagine how our membership in our institutions, which is an important voice in the best sense of the word, in relation to the European legislation, how without a membership in such an institution there could be heard the voice of such a small chamber as ours. Therefore, I am very grateful to the Slovak representatives of the chamber who work at the CCD organization that there is heard our voice in relation to the preparation of the legislation, in relation to the analysis that we can also enforce some things that we as a small chamber couldn't do otherwise. I'm very glad that during the 20 years in EU, we introduced also the free movement of attorneys and free providing of services by attorneys within the member countries. If we are in other area where there is this person limited to his personal freedom, he really appreciates that an attorney from his native country can come. Of course, this is related to the cooperation with the attorney in the country where he is detained, but this is empowerment of the rights of the arrested. In relation to directives that the EU adopted in procedural laws and accused persons, like the right for interpretation, access to the attorney, some directive of presumption of innocence, the guarantees for minors, or general protection of persons who are convicted of crimes. The transpositions were performed in 2013 and to 2019, some in more and less, with more or less success. We can discuss it further on in our discussion or in our subtopics, but today we should have them in our legal order already transposed and in our DNA as well. Negatively, a little bit, I perceive that sometimes in the EU we need to explain like lengths without any lengths, with lengths, that the liberalization of the market is not what we should support. The European Union doesn't understand that the free hand of market in these services is not the right thing, and that there are certain principles without which the authorship as the job cannot work. Whether talking about the institutionalized independence from the state, or whether talking about the confidentiality, or whether talking about the self-regulation, these are all things that need to be set in a certain way as they are set now. At the same time, we know that it's good to compare. Comparison is a very useful thing, but on the other hand, with regard to the traditions and complexity of the whole system, we cannot take granted things if they work in one state, that they would work also in the other state. A challenge in the European area is digitization, AI, online area. All these things, in our opinion, are really the area where the European legislation should be implemented. There is an opportunity for us as the Chamber and my colleagues, the training, education that towards the EU already was supported. And thanks to the training, also contributes this event, the organizer of which we are also a part of, and with honor. Thank you. Thanks to the chairman, Dr. Puchala, and allow me now that I pass the floor to the vice president, Mr. Szeczkaj, and he's also the head of the delegation of the Castle Bazalka CCB. This is the European attorney chamber, and he's the head of the Hungarian chamber of attorneys. So the floor is yours.
Good afternoon, üdvözlet mindenkinek. Köszönöm szépen a lehetőséget, hogy magyarul beszélhetek. Gondoltam, hogy beszélek angolul, de olyan kitűnőek a tolmácsaink, hogy veszem azt a szabadságot, hogy anyanyelvemen beszélek, így könnyebb lesz elmondani, amit szeretnék. Ez a nyelv...
Thanks that I will speak in my language. The problem that we are smoothly moving between English, Slovak, and Hungarian, Polish. This reminds me of Peter Esterházy, a fantastic current writer of Esterházy origin, who died a few years ago, and who in 1990 was an honorable guest and main speaker of the library fair in Frankfurt. And he had the introductory speech, and he started to speak Hungarian. And to a surprise to the people, he said, nobody in the world, he told me that I should speak German. Then he smoothly moved to German, but he said, at least I saw that to those who had eyes flashing, those understand Hungarian. And different from Peter Esterházy, I'm unfortunately not speaking Slovak. I'm going to speak in my own native language. As the attorney, I know what means captation, benevolences. And in order to obtain the sympathization of our audience, Andre mentioned that we have friendship relationships and within the neighborship and within the chambers, and also within the everyday life in advocacy. But besides that, there are more relations of mine to Slovakia, because for other nations, my surname can be difficult to pronounce, but maybe you can understand that Sečka means the same in the Hungarian and Slovak languages. Maybe it's easier for you for understanding. My father was born in Solavar, and recently we found out that our family had many links and relations to Slovakia, especially because my grandfather and his brother were both in Austrian attorneys. My grandfather had a son who was the holder of the surname Sečka, and therefore I'm Szeczkaj, and I always thought that it was a seldom name because no, it's not really the case, because the brother of my grandfather, who was the attorney in Austria, has 3 daughters, and all 3 married Slovaks, and they continued living in Slovakia. And recently, from Piešťany Nové Zámky, they have called me that they are relatives, and that they are also Szeczkajs. And now I will move to the professional issues. I would like to provide you with a complex picture of how the system looks like in Hungary, how the chamber system operates. We have our 20 times more than 20 years ago, after 89 or in 1990, there were less than 2,000 attorneys. Out of that, in Budapest, there were 700. After the revolution, this profession has been fully liberalized. At the moment, there are 18,000 attorneys, and as Hungarian language, and Hungary is a country where 2 million people are concentrated in Budapest. Most of them, 8,000 lawyers, live in Budapest. In English, I would say that we are over-advocated, and so everything is happening in the capital, and it attracts their attorneys and also investors. The chamber in the 90s, in a very good, tricky agreement, unified the chamber of lawyers and attorneys. Their members were such professionals whose employer within the in-house counsel system allowed to establish such teams of workers and provide same services as attorneys. I don't need to say that these advisors 1,000 times better understood the economic laws, and they took over the whole segment of the market, contrary to the attorneys who understood better many trial cases, but they really didn't understand the economic process. By unification, we avoided a tricky thing. I am not here that I should speak here in the absence of Polish colleagues, that I would mention a case in Poland, but in Poland there is split the chamber of legal advisors and attorneys. They have two chambers. To us, we managed to avoid it, and after this unification, or in parallel with this unification, there was increased the number of members. Also, thanks to that, the universities year by year graduated several thousands of graduates, from whom many of them selected the job of an attorney. After such changes, the people had to face every day new challenges, and I believe that the situation was the same also in other countries of V4. After accession to the EU, there was open the market. The western part was very much interested, and the operation of an attorney is following its clients. In the 90s, we were confronted with that the big number of Western American law chambers with perfect English were established in Hungary, and they employed some Hungarian lawyers, but they were not the members of the chamber. Actually, the chamber didn't have the overview of their activity. It was the first step when the representatives of foreign bars we started to negotiate and discuss with, and that it would be useful that we somehow get them under the umbrella of our chamber. And in this way, in the 90s, there was established a separate statute with the title Foreign Legal Advisor, who had the right to perform the legal activity on the basis of the country of his origin, but not on the basis of Hungarian legislation, or to cooperate with the Hungarian law chamber. 20 years ago, there was some progress that Hungary, with other three Visegrad countries, became the member of the EU.
such an entry was preceded by 1-year courses, Lotz and Finlay. These professionals went for 1 year to Hungary and lectured about European institutions and introduced this system. We were sitting together with the Polish, Slovak, and Hungarian colleagues where there was an international conference, and at midnight we celebrated and cried from joy, and from that time the advocacy profession exists and is facing many challenges. And during our 2 days lectures we heard that every day need to learn a number of legal documents. We need to learn about new judicial practices, domestic as well as the European one. So there are a number of challenges, but we try to face them. As regards the Hungarian attorney activities and the obligatory membership in the chamber, the attorney can operate only as the member of the chamber, and with the exemption of one country or two in general, it is in Europe. And we have in Hungary 20 regional chambers, where the smallest has about 100. The Budapest chamber has 8,000 members, and overall there is a general assembly and presidium which performs the coordination activities, protects the interests. So more or less it looks like this in our country. And as regards more detailed questions about our profession, what I want to mention is more in our discussion, and thank you for your attention.
Čo zaznelo v zásade o tom, že od vstupu do Európskej únie v zásade nastala taká skutočnosť, ktorú môžeme pomenovať ako voľný pohyb advokátov v rámci európskeho priestoru Európskej únie. Je to samozrejme opreté aj o právo Európskej únie, aj o to, že súčasťou Európskej únie je aj voľný pohyb chodu a služieb. A v tejto súvislosti je otázka na oboch panelistov, pretože to, ako aj Andráš spomenul, tak v zásade už v tých 90. rokoch bolo aj to isté na Slovensku. Tie zahraničné advokátske kancelárie sa snažili etablovať, ten právny rámec na to nebol úplne nastavený. A v zásade až pred vstupom do Európskej únie, keď sa prijal zákon o advokácii v roku 2003, tak až vtedy v zásade nejakým spôsobom tá právna norma predvídala aj takéto advokátske kancelárie. S tým, že moja otázka je, že aké vy vidíte úskalia v tom voľnom pohybe advokátov v rámci Európskej únie, pretože máme usadených euroadvokátov, hostujúcich euroadvokátov. Aký máte na to názor?
Ďakujem pekne.
Thank you very much for your question. We have been EU members for 20 years. We have the free movement of lawyers. So for the persons which are imprisoned, they are just somewhere. So it is very good if they can be visited by their lawyer, which was selected by them a long time ago. So the legislation says that the guesting attorney can provide the legal services also in Slovakia, or Slovak attorneys can provide their services within the EU, then it is okay. But practically, for example, in Slovakia, there is a problem of communication with law enforcement organs. When there is a problem, to explain them that this barrister from another EU member state has the right to visit the imprisoned person, that he doesn't need a membership of the Slovak Bar Association. It is enough that he has got a confirmation from another bar association of another member state, and therefore he can visit the imprisoned person. We try to push it because also this right for protection, the trust, communication, and relations between the lawyer and his client, that these things will become better. A more interesting situation is with lawyers from the UK. As you know, after the Brexit, they lost this right to provide their services at the EU. It is very important, as I said, that even if we have this freedom of movement, of provision of legal services by a foreign barrister or foreign lawyer from another member state of the European Union, it is always necessary, and it is also laid down in the law, that this foreign barrister consults also the local Slovak barrister who is specialized on the Slovak law. So this is how I perceive it, that the European lawyers who are here, there are 230 of them in Slovakia, and 80% of them are Czechs or even Slovaks who passed the exams of law in the Czech Republic. So, and some of them are from Poland and Hungary, and other states are not have not established here their offices. As I can see, the Hungarian Bar Association has faced some difficulties in this free movement of lawyers. Thank you very much. When Hungary on the May 1st became an EU member state, at that time the foreign EU barristers could open their offices in Hungary, and also cross-border services are possible. But we had to add the respective law a lawyer who is registered in any bar association of the European Union. If somebody establishes his or her office in Hungary and wants to work there, he must register in the local bar association, not as a local attorney, but as an European attorney, and he can make the same work as the Hungarian barrister. There are exemptions for contracts regarding real estates, or if it is compulsory to cooperate with the Hungarian barrister or attorney. We have many foreign, that is EU lawyers, and they have permanent residence in Hungary. These lawyers have been registered with the Bar Association, and they registered themselves as Hungarian lawyers, but when they started their career, they joined our office Then they started as European lawyers, and when you work for a couple of years in Hungary, then after 3 years, you can ask the Bar Association to accept him or her as a lawyer. He must pass an exam. He must prove that he understands and knows the Hungarian law. He has to prove that he had Hungarian clients, Hungarian cases, and there is also a possibility which is more simple, and it is a one-time participation of the European lawyer. And in such cases, there come lawyers from neighboring countries, for example, from Slovakia, who follow their client. It can be some inheritance case or something like that. But usually, we haven't got any problems with the work of foreign lawyers in Hungary. They work very correctly. They respect the Hungarian legal system. The lawyers who work regularly, they have become a part of these offices of baristas. We have a colleague from Denmark who is a very good specialist on the economic competitiveness and the registration in the case of this one-time activity is very simply, and the permission is to work for 1 year. It is typical that during this 1 year the case is solved and it is not necessary to prolong this permission. So we have good experience. I would also like to give you a statistical data. In Hungary, there are about 60 lawyers from the EU member states. Those who make a one-time activity or action, so there are as a maximum 20 or 30 of them. And then regulation of individual profession. How could it affect the lawyers? We have a negative experience with this attempt. A couple of years ago, it was considered by the Minister of Justice to decentralize the Slovak Bar Association, and there was also invited the Venetian Commission. It was very stressful for us as we fought for the independence of lawyers, and this is how I based my question. How do you understand this trend in relation to lawyers, whether they should be regulated or ruled by the Bar Association, or they should be like entrepreneurs and it would be just a licensed business? I spoke about it partially, but I can speak more about it. I didn't attend this negotiation with this commission. It was my predecessor, Dr. Karas, who attended it. But I was on the board, and I understand it that there was a Venetian commission, and we had to explain them that our Bar Association is independent. And we managed to explain it to them, and the Venetian commissions then said that it wasn't clear to them why they had to arrive, because everything was working, and we were happy that they were of this opinion. But self-regulation regarding the independence of lawyers and free market, I can state that all of us sitting here perceiving the relation between the client and the lawyer. We cannot tell that lawyers should work as freelance entrepreneurs. There was a tendency like this 1 or 2 years ago. It only took us a lot of time to explain to our MPs, members of parliament, that it is not like to cut some 100 grams of ham and sell it, because a lawyer has to educate himself. Then he has to ensure, may have an insurance policy. And we managed it. We are very happy. And this nonsense to work as a freelancer was then put away. As I said, there is still the idea of free market and the idea of that everything will solve itself. Has achieved also the lawyers, but as our Czech brothers say, this is not our way, this is not our journey, because the benefits arising from the fact that the person is licensed as a lawyer, these benefits are much more better and significant than deregulation of this profession. For the legal services, it is not decisive to speak about the price, as you would tell, because the European Union has a lot of legal norms in its program. For example, consumers protection. Consumers and the legal services do not need the lowest price, but they need the quality which we can guarantee through our bar association, and also the lawyer receives the stamp, and this stamp is not awarded to anybody. The lawyer has to pass the exams, has to be insured, has to have police, but it is also necessary to have the disciplinary powers which we can manage at our bar association. We also publish a collection of our disciplinary solutions and rulings where we can prove that the bar association is able to deal with members who cross the red line. So the bar association must be independent from the state. These and this cannot be guaranteed by a free business, licensed business. And to become a freelancer, it is nothing for lawyers. And the client, even a client who has no money to pay for the lawyer, this is what we are discussing now with the Ministry of Justice, that people who do not have enough money to pay for a lawyer, they are supposed to get a good lawyer through the help center. Thank you very much. Speaking about this issue, it comes to my mind, it is a quotation from Henry IV by Shakespeare. The rebels who wanted to combat the king said, "Our first task should be to kill all lawyers." But Shakespeare didn't write it in order to express that that he wouldn't like lawyers, because he wrote that those who rebel against the current power, they want to combat the current legal system. The rule of law is very important for us. Hungarian lawyers. One of the biggest challenges after we joined the EU was that we thought that we would send our code of ethics of our lawyers to CCED, and they should assess it whether it complies with the European standards. And we expected that everything is okay, but the anti-monopoly body started a trial proceedings against the Hungarian Bar Association, and because of some limiting measures of the Code of Ethics, the anti-monopoly office stated that we have to publish the fees for lawyers on the website, that we should communicate our marketing activities. There were some limitations, and the Hungarian Bar Association was penalized. We got a high penalty. And we were not expected that we would get a good judgment, because the anti-monopoly body made a big pressure, and we had concerns that we would lose this trial. At that time, we met at the round table with the Ministry of Justice, because the directive on provision of legal services came into force. We also communicated with this anti-monopoly body, and then during the trial we stopped, or the trial was stopped, and we changed our code of ethics, and we modified it a lot. Thanks to these negotiations, we achieved that the self-government of the justice and the anti-monopoly body could understand that we are not usual providers of services, and then we were very, very surprised that we are service providers. We read it in their answer. They wrote about consumers and not about the clients. So they understood and interpreted our jobs completely in a different way. But based on these negotiations, we achieved that all these limitations referred to the basic values of advocacy could remain. So the basic fundamental values of advocacy were defined as of high level, because from the point of view of the safety and security of the legal system, they are more important than other aspects. What helped us was that 2001, the European Parliament issued a decision that regulated jobs or professions prevail the other aspects of competitiveness. Now I would like to ask our audience if you could summarize or conclude whether you see any ethical issues or problems within the European Union, whether it is there are some duties targeting at something good, but there is also confidentiality that is necessary. I would like to continue. I think that majority of problems relates to the application of rules for money laundering, not only in Hungary. It applies to all European countries, and we know about some member states where there are very long-term trials. France, for example, where the Supreme Court supported, enhanced the Bar Association and saved the situation that in some situations it was more important to speak about the confidence and trust between the client and his lawyer, and not the factor of money laundering. There is another change which is applicable, and it is from the banking sector. We get a lot of reports, but from the Bar Association only a limited number of reports. I don't know how the procedure in Slovakia is with regard to report money laundering, but I can tell you that in Hungary the system is very primitive, very simple, and after we joined to the EU and there was discussion of implementation of directives on money laundering. We wanted to negotiate with the Ministry of Justice, which had some sympathy with us, but the Ministry of Finances didn't want to discuss. They said they didn't have enough money for me. We were striving to take the Dutch and Belgian systems because the information come from various resources to their respective ministries of finances, so they can. So it is from Bethany to decide whether the case should be reported or not. Then it is forwarded to experts, where the lawyers decide and financial experts decide. They judge, they evaluate it, they assess it, whether this case is somehow suspicious that it could be money laundering, and if they suppose yes, then they can put it, they can forward it to the police corps, and then also our
a statisztikájára 1000 bejelentés.
Our tax authority investigates these cases. I checked it, about 1,000 reports. 700 of them are forwarded to experts and organization of experts, and these experts, 500 or 600 cases are evaluated as non-money laundering. So actually there are 100 or 200 cases of money laundering at all. And now that how many applicable information are put forward to the police corps. It is not only money laundering. It can also be another criminal offense or criminal activity. Now the modification number 6, how we can effectively improve this system. I want to go back to the original question. The ethical problem is that this is what I said was the biggest ethical problems in the last years.
Confidentiality and the question opened by our Hungarian chamber colleague, the notification obligation. The biggest problem is, and I will make it easier by looking backwards. I stated it on many committees for anti-laundry activities. It was not actually fraud and something like that. A client noticed it, and the financial unit member came, and even he got a fine from the police, city police, and I am not aware how finalize this situation on unusual transaction, financial transaction, but what is important for confidentiality and what we are proud of at our chamber is the way how in the criminal code there is performed the control of advocacy chambers. There was a decision that in searching for material in advocacy chambers, the police could have done only certain things, but they were taking discs without selection of things or files that are important for the criminal case. I can say that in some cases also those things that were important for the given criminal case, they were not searched, but they were searching something else, but they were doing some fishing what can be found and what can be operatively or in a different way used, and therefore I'm proud. And here we can see that we can perceive this cooperation within the neighboring countries, that we were inspired by the Czech Republic, that we got the advice of the Czech Republic how to propose it. And we are glad that one of the recent amendments of the criminal law, there was a specific provision on checking the attorneys' offices, and our colleague's office, where there was inspection made, that the colleague is not in dilemma. This is my confidentially, how shall I protect the interest of our clients, which information want the law enforcement bodies obtain, but it is clear now by the preliminary proceeding judge, these things you can take and these not. So in this case we are back to that in media or lay audience there was discussed, yes, all attorneys want to invent something for themselves, they want to protect themselves more, but the truth at the end of the day is about that. Through such a criminal law amendment is not to protect themselves. The attorneys want to protect the client who has nothing to do with the investigation and doesn't want that in his private data, in his intimate affairs, somebody is digging. And we are very proud of that this dilemma of the attorney who is stressed already when his office is investigated or searched. We also in our chamber had a handbook how to provide, and we need to also give respect to the law enforcement bodies that before this amendment that they also called the representatives of the chambers to participate in these investigations in the offices. There was made a protocol, and nevertheless they took the whole hard disk, but now it's handled in that way that it should be, and that there are guaranteed the private data of the client. I can only add that the European rights of professional are under the Article 8, the protection of privacy, the communication between the attorney and client. There was also a decision of insufficient legislation, that it's breaching of Article 8 on the right of human rights. Now I can give the floor to our colleagues in the audience if they may have some questions. I know it's quite late and the day is long. We still are ahead of the reception. So, Mr. Trstinsky. Thanks for the floor. One note, how we are developing the attorneys' jobs. I was present with all these after the 70s, 1989, I was the assistant, and in December, I had the paper which gave me the rights to provide the legal sources. It was a problem to obtain the profession certificate, but in the end we managed to establish the commercial chamber, but the attorneys were not satisfied because we were saying that they are for criminal law. So we mostly had clients who were paying better, but in the end, all was unified, and we can say it's good in Slovakia that we have only one chamber, contrary to Poland, and that I cannot do it only as a side job. So by historical memory, I want to turn your attention how we developed, and this is the best solution probably. I'm still the attorney, but I'm more in business, and I'm helping also to the faculty of law as a former teacher in this area. This was just to make a historical shortcut there. Thank you. If there are no more questions, the one more, yes, Mr. Schlaschter. Good afternoon. I want to ask, and maybe to pick up the gabla, and I would like to ask the president of the Supreme Court, who a little bit doubted about the independence of the half membership of the Judicial Council in relation to the Venice Committee. I don't know whether it was adopted before or after the last amendment of the Constitution, but in this relation, as in the Council, there operate 6 attorneys. I want to ask whether the attorney is facing or not facing any dilemma on interference of his independence, how it is in operation of attorney in public function like a deputy of the parliament. What is the context that the attorney, when he is an attorney, regardless to where he operates in other places, is he for 24 hours an attorney? And maybe in connection with the honorable guest from Hungary, I want to ask whether similar experience of operating attorneys in performing public functions, or maybe right or wrongful criticism they also face in Hungary. Okay, thank you for your question. Professor, this is really a question that could cancel also the evening reception, because it's so broad that I don't know in which way to tackle it, but I'll try to make it shortly. Basically about these things, whether the attorney in politics or in public functions can or cannot express himself in this or that way, and there are discussions in our presidium quite often, and maybe there was a proposal that in such connection the attorney should suspend his activity, because it's not a question to the council members, because Judicial Council members, because there is not such a conflict if the attorney works in the politics, the expression he gives can be punished or not punished through the Chamber of Attorneys. But this is a sensitive issue to say that this is the expression of an attorney still, or this is the expression of or standpoint of the council or a politician. It's really difficult. And I believe that it should be like that, that it's always on the concrete, up to the concrete person, that it considers all these connections. Once he is an attorney, he should behave as an attorney adequately, and also as a member of another body, but also as a politician. And then the question doesn't need to be asked, because it can be resolved by the behavior of the person itself. But it's so complex, this question, that I am not really trying to give you the concrete answer now. It's really a very sensitive question. As regards the Hungarian legislation there, in a certain way, we are dealing with such a situation that the law on attorneys bans that for performing the legal activities, somebody is also doing the attorney work. The only exemption from this criteria is the legal advisor registered with the chamber, but there are so many restrictions that actually he can represent only his employer. As regards the Act on Attorneys, this also regulates the activities. I will not list them by heart, but some of the examples can be that there are activities where there is not occurring such a conflict situation, that when there is not occurring obligation resulting from the employment relationship and other commitment from the position of the attorney, like the activity at the pedagogist at the university. Such a conflict doesn't occur because there is not performing of instructions for doing the political or public function. But we have many active politicians in Hungary who formerly, also Mr. Tuzan worked as an attorney, the current Minister of Justice, and when he started to be politically active, he suspended his attorney activity. That means he's a member of the attorney chamber, but he doesn't perform his activity. But how he practically works and operates, whether he thinks in his soul or mind, whether he thinks as an attorney, but actually he cannot practice as an attorney once he is performing a public function. Minister Uhl. Thank you. Not a question, but I can react to the question posed Mr. Slashan. One thing is the question of a moral dilemma, and the other thing is our legal status applicable. I would like to turn your attention on the constitutional law and the operation of public functioning person, that he cannot do business, but the business on the basis of specific functions like attorneys, doctors, artistic activities, there is an exemption, and there is also a decision by the Constitutional Court that confirms this exemption. So this is rather a question to moral level, but as for the law, by the constitutional law, it is settled Thank you, Minister. And this is a very good full stop, I think, after this panel. I would like to thank to the Vice President of the Hungarian Chamber, Mr. Secskay. Thank you very much for coming. We appreciate a lot. And also to the Chairman of the Slovak Chamber of Attorneys, to Mr. Kuchala. And to you all that you were in such a big number here, and also for the minister's attendance and the state secretary's attendance. Thank you very much. Thanks again, also on my part, to our partners, to the Ministry of Justice of the Slovak, to the Ministry of Foreign Affairs, to the Supreme Court, to the Slovak Chamber of Attorneys, to our financial partners, V4 Fund, and to Central European Foundations, to our media partners, the Economic Journal and St. Nicolaus company, that we managed to organize such a plenary session. Thanks a lot that you came, and there is nothing left than to invite you on the ceremony of this event at the Hotel Devin at 18:00. You enter from the Devin entrance and you are invited warmly for the reception there. Thank you.